All right.
Reserved for judgment on Monday, my lords, 9th. We have
Which-
prepared a synopsis.
Which writ appeal?
Two writ appeals were jointly heard. This is pertaining to allotment of industrial plot in Azamabad industrial area on Monday, my lords. My senior forgot to ask for, he has prepared a synopsis. I am seeking your lord's permission to submit this in the good.
Four connected writ appeals followed for
Huh?
5 days. Four connected writ appeals of the year one.
Huh.
First one of the year 2009, Morod, appeal by state, Morod, and requesting.
What you want final hearing? Move an application for.
There's an application.
Please move.
In my appeal, 2014 appeal, I filed.
Huh?
In my writ appeal, it's filed.
You don't know. Every day we are required to tell that we don't grant final hearing by mention memo. Please file an application. We'll fix a date.
Correct.
Please, Your Lordship, I beg to appear, my lords. Lordship, the order is at page, the impugn order is Lordship would find, my lords would find it at page 17, my lords.
But the only thing is, we are not convinced, but the only thing is you could have approached the single judge seeking vacation of stay.
I am beholden, my lords. My problem is the building would have been demolished, my lords, by that time.
Demolished, it's this thing,
My lords, may I,
removal of seals.
yes, my lord, but the demolition, Lordship, may please see page number 87, my lords, the photograph 83. Photographs, Lordship, may kindly see, my lords, for a minute.
No,
If the seal is opened, my lords, if the seal is opened, the building gets demolished. He gets access. The writ petitioner, before the single judge, my lords, gets access and he demolishes the entire place, my lords. Graves have been desecrated, my lords. 4 graves have been demolished. I have filed photographs of all those things, my lords. That is my only urgency, my lords. It's my only anxiety in filing with present writ appeal, my lords. Lordship, may please see.
Your Lordship, we seal the property on receiving the complaint that the
who is
property
the
is going to
petitioner?
be demolished.
I'm for the petitioner's here. I'm for.
that,
But
how can you, this thing, Mr. Demolish?
it is.
We will, this thing, what we will do is, senior counsel, what we'll do is that we will restrain him from demolishing and you file an application for
Yes, but-
seeking vacation of the stay.
Yes, my lord.
May I say, my lord, one thing?
You can't demolish like this.
I
right?
can't demolish it because partly it's been demolished because it's my house. And in fact, my lord, sorry to say,
That is the dispute.
That's
Mr.
what-
That is to be, and he is entitled to be heard, right? He is not even a party in the writ petition. I mean, if any order is passed which affects his interest, he is entitled to be heard. That's why we asked him to move an application. But since there is an imminent threat of demolition, so don't do it. What is there for 1 week or whatever?
I'll do so.
Till his application is heard and the orders are passed.
Yes.
That's all.
With great respect to the senior counsel, my lord. In fact, matter was passed over before the single judge.
No, Mr. We will ask you very inconvenient
Yes.
questions of which we are sure you don't have an answer,
Just I want to.
right? So we are trying to find out an amicable solution to this problem. How can, if we ask you, you can't defend this order. We will tell you for the reason. The main relief in the writ petition is the same, which is granted by interim order. Can this be done by an interim order without hearing parties? Can a writ petition be allowed?
Yes, just 2 minutes, but I
The
just.
2 weeks, that is it. So therefore, on this ground itself, it is liable to be set aside, but we are not setting aside. We are really, we should understand this,
Only
this intra-court appeal.
I want to bring to one notice to your lordship. Permit me, my lord, one notice, one thing I, because in fact, my lord, when matter was passed, when the senior counsel has argued before the single judge.
No, nothing, there is nothing to argue. We told you, don't demolish. There is nothing, the matter will be you engage him before single day.
Demolish.
Don't demolish, that's it. Heard on IA 1 of 2023 for the
The orders of removal of the seal, they may be kept in abeyance till everything is done, my lords. That's all I request.
Your only apprehension was demolition that won't be done.
Entry is also be there, my lords. In the meanwhile, because tomorrow itself the steps will be done.
Cannot be demolished and status quo.
May it please your lordships. The challenge in this writ petition is late, to the entertainment and directions given by the Human Rights Commission to the GHMC to demolish the petitioner's property, by virtue of which, the petitioner's property has been demolished. I filed a petition.
Too late to realize.
I came to know only when I filed a writ petition.
Learned counsel for the petitioner submits that the
Three,
we
eight,
don't
two,
know
five,
what
six.
it is. These are different properties, different claims.
No, same. When I filed a writ petition saying that GHMC did not follow the
What
procedure,
happened to that petition?
it is pending. During the course of hearing, I came
List
to
for analogous hearing along with WP number.
38256 of 22.
All.
Obliged.
Yes.
Administration.
Hmm.
Please, my thoughts.
Huh?
Presenting on behalf of counsel of the petitioner, my lords.
Huh?
My lords, this writ petition is filed, my lords.
See, you are appearing for whom?
Petitioner, my lords.
Huh.
Petitioner counsel, my lords.
So you appear this thing stand in a place meant for respondents and say that is the confusion, madam. That's why if you stand here, we would immediately understand without saying that for whom you are appearing. That's why we have put these boards.
Yes.
And we hope that you all are aware that this is meant for you people. Yes.
What is the
Also,
pay fixation? What is
My lords, this writ petition is filed, my lords.
fixation?
what is the prayer?
My lords, to consider the representation of the petitioner, my lords, wherein the respondent number 7 is causing a great inconvenience to the residents residing in in that place, my lords. Wherein the poultry farm.
Will dispose of.
Now, this is a issue is
Yes,
directly
in
covered
this
by the
writ petition. Who appear? Not be present.
They have not even completed 10 years.
Questioning the
We have completed 10 years.
respondents.
On that day.
Already this fellow,
In
this
this
petitioner before
furnace
the last
concept,
paid
Supreme
26
Supreme Court
installment
judgment.
out of 30
Rajan
installments.
completed 5 years of service.
Ajay, what order you are challenging?
Security.
By Ambul submission without being hearing the
So-
petitioner, they have
For your
unilaterally
submit
taken
case
the
papers.
Remedy under 17.
Your matter.
by Ambul submission is, I have already paid in the.
We don't know. We don't maintain the account. High Court doesn't maintain what amount you have paid.
These are the relevant documents are. Sir. They are
No, no,
not-
mister, you have read Satyavati Tandon.
Yes,
Satyavati Tandon's judgment, Supreme Court, 2010.
yes, sir.
What, 3-judge bench, Article 141.
By Ambul submission.
You have why do you come here? You have the remedy, the debt recovery tribunal is in Hyderabad. You have the statutory remedy to approach it. Why don't you go there? We don't know. There is no requirement to pre-deposit in DRT.
There is expressly, there is a crystal clear violation of.
Not crystal. What is, then how do we violate Satyavati Tandon? Supreme Court has, yes, madam, that 14th thing. Heard on the question of admission in this writ petition, the petitioner has assailed the validity. Yes.
Agreed, your lordships.
Hmm.
Agreed by the orders passed in IA number 1467 of 23 in SA 238 of 23. The Honorable Debt
So
Recovery.
two remedies, either to seek modification of this order, file an appeal, same principle,
Lordship, here I'm a third party, not a borrower nor a guarantor.
whatever.
Lordship, may
Any
consult
person,
page 17 of the order passed by the Debt Recovery Tribunal. 17, my lord, for a moment. According to the learned counsel for the petitioner, they are the absolute owner possessor of B scheduled property. Their vendor purchased the same under registered sale deed 21/2/22 and the petitioner in peaceful possession of the said property. However, they received the summons from the civil court filed by respondent number 2. Here he is the borrower from the bank. In the civil court, second respondent is claiming the schedule A property situated in plot number 131. Petitioner also filed OS number 207 of 23 and a status quo order was passed. However, on 28/4/23, the first respondent officials came to schedule B property and tried to take physical possession, which is under challenge in SA. So, Lordship, the property under dispute is seized before the civil court. Lordship may kindly take a page 98, the plaint filed by the respondent before the trial court, wherein I have been arrayed as a defendant in the suit. I entered my appearance substantiating my contention before the court below. Lordship, here I am not a borrower nor a guarantor.
No.
But the tribunal has directed me to deposit 7.
Section 18 doesn't say that only a borrower or a guarantor can file an appeal, anybody.
Lordship, my source of title is from the original owner.
We don't decide.
1986.
We don't decide title under Article 226.
Not
Two
about-
constitutional bench decisions have said so.
Lordship, 17,95,000 is a huge amount to be deposited by the petitioners in the interest bearing no lien account with the respondent number 1 bank. So my submission is that neither I'm a borrower nor a guarantor. So I prefer an essay before the debt recovery tribunal claiming the property. I'm only seeking a suspension of the order so that essay can be disposed of on merits. Because I'm in position, he categorically admits in his own suit that is filed for declaration and recovery of possession. And the source of title of respond number 2 is from 2006, whereas my source of title is from 1986. Petitioners can't deposit so huge amount, my lord, and the time frame is fixed by 2010, 23. Quarter amount I am ready to deposit, my lord, because I'm not a guarantor nor a borrower. For that reason,
This you are telling third time. We have understood. We will answer that, neither a borrower nor guarantor. We will answer this argument. Anything else?
nothing, my lord.
Yes. Give that in this writ petition, comma, the petitioner has assailed.
May please, my lord. Listing the petitioner, my lord, as non-local, my lord, in US, UG Ayush, my lord,
Order.
page 13, my lord.
Why have you come now? 19.
Ayush, my lord, only the petitioner made application, my lord. 610, my lord, the note. Lord, ineligible list was published on 610, 6th of October. Lord, petitioner studied your first class to 10th class in Telangana. Lord, 2 years in Maharashtra, my lord, Pune. Lord, is not eligible, my lord, as per the presidential order.
No, but why this thing? This we have dismissed similar petitions, right?
Yes, yes, Lord. The petitioner, my lord, pursued our education, my lord, 1 to 10, my lord.
No. Mister, this doctrine of fence sitting, right, applies. You were sitting on the fence when everybody else was fighting it out in the court. You waited the judgment to be pronounced on 29/8, and thereafter, after 6 weeks, you have filed this petition claiming the benefit of the judgment. How can we grant? We have not even granted this thing. We have confined expressly in that judgment the relief to the writ petitioners, and subsequently other petitions we have dismissed. So we are bound by our order. We cannot take a different view in your case.
The petitioner only made, my lord, application, my lord, in pursuant to the notification, my lord, of page 25, my lord, on 28/9 only.
28-9, page
What
25.
is MBBS code?
That is MBBS millet, is Ayush millet.
It is I
Ayush
that
court, sir.
now going to be they only got ready millet, the merit
That
list.
is the notification in which the petitioner was declared as a non-local. 6th October.
No, so when you notified this process of admission to Ayush course?
The notification millet has not filed.
On 6th millet,
Six.
is the.
No, process of
I made
notification.
application page 25 millet per minute. Page 25 millet, I made.
No, don't
millet.
teach. You are here to assist us. Tell us when the process was notified, like when it was not the process commenced for admission to Ayush course. When they issued the notification? When did you apply? When were you declared non-local? All these dates.
It's only on millet, my instruction millet on the 6th of October millet, this merit list millet, page 13, 13 millet.
He has not filed millet, prospectus millet, notification.
Deliberately, they have not filed. When?
I will place millet if that.
Please.
Tomorrow millet. Tomorrow, Lordship,
Why tomorrow?
because I could.
You file incomplete petition without pleading facts and
That's
compelling
only-
the court because
only
of
to-
your inefficiency. The court should list it tomorrow, right? Because why should you draft the petition half-heartedly? You should come to the court with clean hands.
Only the notification millet, I'm.
Why date of notification you should know when the vacancies in Ayush were notified. When did you apply? All these are relevant dates.
I
or not?
applied on 28-9 millet, page 25. 25 millet my application millet. On 28-9 millet 2023 I made application millet for admission. Along with my
Yes, Mr. Rao, what is it?
The notification was issued millet 25/9 Lordships. Online applications.
Yes.
Millet on scrutiny of the applications, the petitioner was found non-local, having regard to the fact that 2 years he has studied outside the state. No name. As per the presidential order, the notification also clearly states who is local, who is non-local.
But this issue we have dealt with in that
The
29.
Lordship kindly see, my lord, the petitioner filed a residency certificate. Residency certificate issued by Tahsildar. The petitioner stayed only 1 year. But that is at page. At page 23, Lordships.
One year.
1 year.
this millet I made again application millet, but in the double bedroom process millet they could not provide millet. I made application millet for 10 years millet. I'm going to get.
So they on your own showing this like
In usual course millet they given millet. This
no, they are more cautious because we have been telling them that these officers in collusion with candidates are issuing certificates for extraneous consideration.
Stated millet, the petitioner along with the parents millet, permanent resident of Telangana millet, they have properties, they are own.
No, Mister, this is your document. What
Yes,
do you say?
yes.
You have annexed it.
I to agree millet, but I made application millet.
No, this thing doesn't matter. Agree, disagree. Doesn't matter. It's your petition. You have filed it. What is this?
Lordship, so please just
On your own showing, you don't fulfill the requirement. The residence certificate annexed by you doesn't say so. What is it? What basis you are claiming?
millet up to 10th class millet, the petitioner studied in the Hyderabad only. And she is the permanent resident of Telangana millet, Hyderabad. Lord, so please millet, I will withdraw this petition. I file with along with all details millet. Liberty may be given. I will file tomorrow itself. With the notification and all that.
What? Yeah?
This one. She left on 23/7 told me from Pune. 24/6 I can to fit in 1 year. So that we will be confused.
What application, what better affidavit you can file?
Along with notification and the resident. residence certificate, my lord, about 10 years.
Fresh petition.
Residence certificate and the notification, my lord.
See, if liberty is granted, what better affidavit you can file? You can't change the documents, right?
Notification and when I made and when they.
No, that we have got it from Mr. Rao. So how you are this thing?
Residence, my lord, I made application, my lord, the view of the revenue people, my lord, are busy in some other government activities, my lord, they could not provide, my lord.
No, this says only you are residing for 1 year.
Yes, my lord.
Then
That is, my inadvertence, my lord.
inadvertence.
I made for rectification of this document, my lord, I am getting, my lord, that I will place that residence
So then
certificate.
why did you file this petition then? With until the document is rectified, just taking chances, right? Let's see if the court grants the relief, fine.
I am sorry, my lord, that is not my
Then
intention, my
what
lord.
is this, Mr. Your
On
own
page-
document at page 53. Obviously now you are trying to influence the Tehsildar. Mr. GP for revenue. For a change, Tehsildar has issued this thing correctly. He is saying that I will get it rectified certificate.
Since I am a resident, permanent resident, my
You
lord.
will instruct this Tehsildar Khairabad to adhere to law and not come under the influence of the petition. He is saying that I will get it changed.
Circular has been issued to all the Tahsildars.
Huh?
The residence certificates. Circular has been issued to all the Tahsildars in the state.
No, they factually incorrect this thing. Certificates they are issuing. I mean, anybody, it's not petitioner's case and they are writing. He himself is saying I am away. Like in some cases we have come across that we are living away from Hyderabad. He says yes. 12 years. he is here.
Already had a notice, my lord, Gajwal.
Huh? Now he is saying that I will get it changed from Tehsildar.
Actual certificates would be issued.
He says, Mr. What do we do, Mr. On your own showing? This thing, you have relied on this residence certificate, you are relying. What have you said about this? Have you said in the petition wrongly issued?
That
Nothing.
said, my lord, that I got only
At the most we can do is to permit you to withdraw.
the liberty, my lord, to file a fresh, my lord.
Come up with better pleadings, right?
Yes, yes, lord.
Huh?
That liberty may be given, my lord, I will come.
After arguing the matter to some extent, learned counsel for the Yes, Mr. Rao.
B and C registration.
Yeah.
May I please your lordship? My
Yes.
lordship, this writ is filed for not considering my registration under B category in need my lordship. I have applied for A category, my lordship, but unfortunately.
Representation.
Yes, sir.
Page.
With an online registration, my lordship, it has not accepted online. That's why I have come before this honorable court.
No.
He has not filed copy of the order passed with Sam.
Copy of the order not. You file a representation that university will look into it. This is the order which we have been passing, right?
My lordship. If they consider my lordship, it's a matter of her life. It's a lady, social
Huh?
economic candidate.
Matter of what? Matter of
Life.
life.
Life, it's a lady candidate, my lordship, and she
No,
comes
so
from-
life depends upon admission to. Why do you did not then? Please be ready. to Answer such inconvenient question. Just a minute. So, when did you apply? What was the date of this thing? When the vacancies were notified? Which course?
13/7/2023 for MBBS BDS, my lordship. I filed on
13/7.
13/7. Yes, my lordship.
13/7 MBBS BDS. So, what was the last date of applying?
Yeah, already it was accepted and I went.
No. You tell us last date of. What was the last date?
Last date I was not aware, but I applied before the
Then-
of the counseling, my lordship.
This. It's a question of life, right? That's why we are taking it seriously. You are not prepared to answer the question. Huh?
my submission is we
No,
want
no,
to go
no.
for category quota also, my lordship. It's humble submission. If they consider it's a
No,
management
no.
quota.
Please tell us what is the last date? When did you apply? Under which category?
I applied on 13/7/2023, my lordship,
Huh?
under A category.
Which category?
A category.
When?
13 July 2023.
That was the date on which it was notified, right? Same day he applied.
No, he has not applied.
Mr. Rao is saying you have not applied.
I have the documents, my lordship. When I have applied, you can see page number, my
No,
lordship.
applied under which category?
Under A category, my lordship.
What is A category?
A category is on the basis of merit, my lordship.
Huh? Merit.
Merit.
So now you want under management.
That is B category.
So why you did not apply under management category?
Yes, my lordship, because I was expecting my seat in the A category, but unfortunately I was.
Can you be permitted to do so under the rules?
My
A
lordship,
candidate who has not applied, what statutory right do you have? That I will not apply and then I will file a writ petition, High Court will allow that and permit me to, under what, which rule you have the right to apply for management category subsequently?
my lordship. I was
Where are the rules? Tell us, which page?
page number 14, my lordship.
Page
Page number 14, I applied.
14. No, rules, mister. Rules. That you have not applied under the management quota.
Yeah, I have not applied under management,
Then-
but I applied in
then-
the category, my lordship.
Now you want subsequently whether it is permissible under the rules to do so. That is the only thing we are asking you.
My lordship, if you
Where are the rules?
would have inherited powers, my lordship, they can even apply, even go for consideration, my lordship.
Huh?
Court has vast inherited powers, my lordship.
Inherent powers to grant relief contrary to rules.
The procedure is we have to apply it separately, A category, B
Huh?
category.
No, mister. Court has inherent powers to grant relief contrary to rules.
But the main reason was, my lordship,
No, where are the rules?
as per rule, you have to apply it separately, my lordship. That is the rule.
So where are the rules? You are telling it's a question of life, therefore we are taking it seriously. So we're asking where are the rules? Yes. Which page? Have you annexed rules?
Yes,
Huh?
as per the rule, my lordship, you cannot go for that, my lordship, as per the.
Huh? Where is the rule, mister? Along with just like arguing without this thing. Where are the rules?
It is mentioned in that online test itself, my lordship.
No. We want to know under which provision subsequently you can apply. You have to show the rule before you can get the relief. That you are not, we will write in the order that he is not answering.
Rules, I'm not much aware.
Then not aware, we are also not aware. So then what should be the result? You are also not aware, we are also not aware. Because we are not seeking admission under management code. So we don't know about the rules. So you also don't know. So good, the petition should be dismissed then in such a case.
The college, when we approach the college asked if we can get a consideration order also, we will take admission in management quota. That is the request, my lordship.
Request.
He has to make a representation to the university.
That we told him in the beginning, he doesn't understand. He's saying it's a question of life. We told him in the beginning that you submit a, see, mister, this is all contrary to, you can consider and give relaxation. Court cannot pass an order like this in contravention of rules. That's why we are asking him to submit. He is not willing to understand what can be done.
But if we make a
The
representation,
petitioner should only thank him for engaging a lawyer like his caliber. What can be done? Unfortunate. We told him in the beginning. He is not ready. He is saying that it is the question of life. What can be done?
My submission, my lordship, if time is granted, I will get the rules by tomorrow, my lordship.
Ah, Yes, learned counsel for the case for adjournment.
Obliged, my lordship. Very much obliged.
Arey, mister, it's unfortunate. You are saying obliged and all this. This is unfortunate. You do not understand. We are granting you liberty to submit a representation with regard to your grievance to the university. It's all, whole thing is time bound process. You would be, petitioner would be suffering.
My lordship.
There is no provision under the rules. Why don't you understand? What will you do by the filing rules? There is no provision in the rules. You have missed the bus.
My lord.
You did not apply. We are asking you to go to this thing, university. You are not prepared to understand what can be done. You file rules. Let what he is unable to comprehend what can be done. Unfortunate. That's what we can say. Yes. Necessarily the two petitioners suffer. What can be done? We deliberately cannot make her file a representative.
Hearing for the petitioner in this matter, Lordship.
So which revision of electoral rules under which provision, Mister?
21, section 21, subsection 3 of the People's Representation Act.
So High Court is the appropriate authority to undertake the revision of rules, right? We should,
I may direct the election officer.
it will be done, Mister.
Lordship,
What makes you believe that it will not be done? Revision of electoral rules, the moment election program is issued, it will be undertaken.
for a single moment, Lordship may be right.
Of course, we will hear you. But we just wanted to know, since we have read it, under which provision this.
Section 21, subsection 3 of the People's Representation Act.
Representation of People Act. Yes. Section
21.
Yes. No? Yes. Why it skipped here?
Section 21, Lordship, may I permitted to read that? Preparation and revision of electoral rolls. Subsection 3.
No,
Notwithstanding.
Mister, this petition is based on an apprehension that the election commission will not revise the electoral roll and therefore I will lose again for the fourth time.
Even after giving representation, there are
What is, Mister, what is this thing when an election program is notified? What all it contains? It contains that revision of electoral rules also, right?
That's what I wanted to.
That exercise.
What the?
No, Mister, 1 minute. They are under a statutory obligation to undertake the exercise of revision of electoral rules, no dispute. But what makes you believe that they will not do it?
Lordship, it is not. That is what I am reading. The very act. Section 21, preparation of revision of electoral rolls, subsection 3, Lordships.
Yes.
Notwithstanding anything contained in the subsection 2, the election commission may at any time, reason to be recorded, direct a special revision of the electoral rolls for any constituency, part of the constituency in such manner as it may think fit. Lordship, today is 12th October, polling date is 29th October, 52 days are there. Today is 12th October. 12th October. It's still 50. There are more than 1 month is there to take a drive. There are more than 1 month is there to take a drive for special revision and remove all the votes. The height of the case is even foreign national names are there in this. Foreign country national. But volume number 6 will be produced. Volume number 6, Lordships. A letter was addressed by the Chandanpeta police station to the district election officer to remove the name of foreign national. They have not been removed. Lordship, peruse volume number 6.
No. So before this thing, we want to understand what is the process like before holding of election. the election commission is required to undertake an exercise of revision of electoral rolls.
Yes, yes.
Correct?
Yes.
This exercise will be undertaken. We don't have any reason to presume that they will not do it,
They have not done it. They have not done it.
and
But
they will not do it.
on the direction they may do it, otherwise they'll
No,
come
no,
to
no.
the contempt.
Why? So what makes you believe like this is, please understand, mister, until unless a legal injury is caused, right, in anticipation, you are presuming that they will not do it.
I am,
No, mister, we are trying to understand. It's a debate, right? We are not against you. We don't want you to lose for fourth time. So, 3 times you have lost on account of this thing revision. This is your case, correct?
Yes.
So we don't want you to lose. So, but in order to entertain a petition, there has to be an infraction of a right. The right exists in 22(3). They are under, but what makes you believe that they will not undertake?
even today, this print was taken out yesterday night. Of the some foreign country national, their names have not been removed so far. Some foreign country nationals are making.
No. So under Article 226, we decide who is an Indian national, who is a foreign national, who is dead, who is alive.
I am not saying this. A police officer addressed a letter after inquiry.
Have you approached, 1 minute, have you, before filing the writ petition, have you approached the
Yes.
election commission?
Yes. Yes.
You are appearing for,
Even seventh election.
for the candidate, rival candidate.
Oh, my lord, I'm appearing for the election commission.
We thought that.
Seven representation given to the concern officials.
Where is
That is on 16, my lordship, my
Where
page
is
16.
that? Where is each page?
Page number 16.
16.
16, 16.
16. 15 June.
The representation dated 15 June 2023.
All right. Yes.
Similarly, next page,
Ah,
17, 18, 19, 20, 21, 22, 23, 24.
well, enough. We only asked one.
7 representation given to these
Given.
people to remove the names.
All
They
right.
have not taken such steps so far.
All right.
That is my complaint.
Yes.
Yes, but page 31, well, it is a reply to the representations which has also been given to him. The CEO of the state has sent to the Election Commission of India on the action taken on the representation.
No, Mr. Before conducting elections, will you not take up the work of revision of the electoral rules?
Yes, sir, it is necessary, section
Then
21.
whatever, I mean, it should not contain the name of dead people or foreign nationals.
The attempt is always to ensure that the electoral rolls are as pure as possible, and it's a continuous process of revision. Before a general election, there is a general revision as well under section 21(2), which has also happened.
That is his grievance. When
Which is
will you
also-
undertake the work
Yes,
for
but-
revision of this electoral rolls? You tell us.
Okay. The notification was given on 4th July, and by 4th October 2023, the final publication of the rolls, revised rolls, has happened. But now, anybody who has a grievance under section 22 and 23 of the RP Act can file an application read with the registration of electoral rules for deletion, inclusion, or addition up to the last date of filing nomination, which is on 10th of November 2020.
When did you undertake the work of this thing?
That is the notification that I've passed on. And this is the Election Commission by letter dated so and so, dated 4/7/2023, has issued revised schedule for the revision activities on the second special summary revision photo electoral rolls with respect to 10/1/10/2023 as a qualifying date, and shall now be done as per the following schedule. But all this was done: application of draft roll, then period of filing claims and objections, then disposal of claims and objections in September, then checking of all the parameters, then final publication of the roll was done on 4/10/2023. But his representation was also considered, and that also replies there at 1/9/2023 in the writ petition itself. It is fine. Then this 4/10/20.
1 minute, what have you said in your representation? That
The
reply?
reply, consistency at page 31. Before I
190.
come to that, I just wanted to say, when this says as final publication of electoral roll, that does not mean it is the final roll. There can still be changes. But the larger summary revision, that is the final publication. Now, the changes will be made on every information that is received, and in forms 6, 7, and 8 for addition, deletion, and transposition.
So under which provision anybody can make objections?
That is under section 23. What this exercise is under section 21, which I just showed to your lordships. Then section 22, correction of entries in the electoral rolls. If electoral registration officer for a constituency or an application made to him or on his own motion is satisfied after such inquiry as he thinks fit that any entry in the electoral roll of the constituency is erroneous, defective, transposed, etc., then the electoral registration officer shall, subject to such general or specific directions, if any, as may be given in the election.
22C.
Yes, 22 A, B, C shall amend. But at the time period till when it can be done is in section 23. 23(3), your lordship has seen. Any inclusion of the names in electoral rolls, but that is also changes.
No amendment.
No amendment, transposition, or deletion of any entry shall be made under section 22, and no direction for inclusion of a name in the electoral roll of a constituency shall be given under this section after the last date for making nominations for an election in that constituency or in the parliamentary constituency within which the constituency is comprised and before the completion of the election. Normally, it is a continuous process of revision. But if there is an election, the last date for which in which changes can be made is the last date for making nomination. But in the present elections, the last date for making nominations, this is the notification that has been issued.
What is the last date?
It is 10/11/2023, 10th November 2023. And 10 days time is required for any inquiry. So usually all the complaints that are received 10 days prior to that, but are all dealt with by the chief electoral registration officer, which is done in terms of registration of electors rules and the forms prescribed thereafter. Registration of electors rules 1960. And if there are any objections can be put forth even in respect of the final draft publication. It's a continuous process till 1st of November. The complaints can be received normally. But even now they have the chance of giving that because they have the final roll. In addition, at page 31, there is a reply given to him on all the details of all the complaints that he has made. The endeavor of the election commission is to ensure as much purification of votes as possible to the best effort.
You want to?
Yes, I want, sir. That's
All right, so then let him file if you want to contest.
yes, yes.
Let him file a counter so that, advocate, this thing manner, it has to
At
be,
least-
you file a short counter stating that
Yes.
this is what is the process. He wants to dispute. Otherwise, we thought that we could have permitted him to raise objections under 22 and 23 and you could have been directed to decide. But he is not interested in that.
Lordship,
What
I
can
have-
be done? Yes.
I have.
So,
But while
Right.
we have accepted, his representation has been considered and dealt with, and action has been taken.
this all has been done, so you place it on record.
Will place-
This objection can be that it's not on record.
My,
I have not been given an opportunity.
My-
It is to be, right, mark the presence.
one small submission, Lordship.
No, we are
I
not
done
doing
it,
anything. We
submitted.
are asking him
Action has
to,
been-
1 minute. We are asking him to file a short affidavit so that you can be given a fair, all this should be, it will be on record and we can decide thereafter. We had given you an option which you have declined. We will have to decide it. We'll decide it. In this
So the order,
Huh?
order copy by today evening, Lord.
Why?
Because it's time.
We have not passed any order.
Any.
No, you want to this is what we, publicity interest litigation. Focus on your constituency, right? This, or we could have dismissed the petition today itself, mister. We are being fair to you. That doesn't mean, all right, we'll pass an order. But that's it.
No.
That's how it should be. No.
I apologize.
No
I
question.
apologize, Lordship.
Sorry.
I apologize, Lordship.
We didn't realize that it can have so ramifications.
I
Correct.
apologize.
No.
Lordship, I apologize.
Yes, heard on the.
Volume number 1, Lordship. Volume number 1.
Volume 1. Page, I guess. What is it? Volume 1.
This is the information, deceased person death certificate and their names in the electoral roll company assembly. Deceased person's names. Death certificates, I'm filing the deceased person death certificates and their name are still existing in the electoral roll.
Volume 1 is the list of dead persons.
Dead person.
All right.
They are
How many of
10,000. These only their tips of
How many persons?
more than 10,000. They are the only tips of iceberg. I have given all the.
No, our number you have to give. According to you, we have to decide, right, in a writ petition that these names have to be deleted. So you will have to furnish.
$10,473.
10,000.
473.
All right. Yes.
Various type of bogus votes non-existing 34,867.
Non.
Non. 4,867.
1 minute. We are writing bogus voters. 30.
4,867.
867.
Yes.
All right. Next.
Person having more than one vote. 16,468.
So where from you are getting all this?
Giving information to volume wise.
Volume.
Because I have already researched a lot.
All right.
Yes.
Oh. Yes.
16,468.
1 minute. More than one vote is
16,468.
468. Yes.
Person having vote in this constituency and other constituencies. 5,937 votes.
5,000.
937 votes.
2 constituencies.
Have given
They are enrolled as voters in 2 constituencies, right?
The Gochamel constituency.
Whatever. 2 constituencies.
Yes, 2 constituencies. That is 5,937.
Hmm.
Total number is 1,13,310.
1 lakh
13,310.
13,000
310.
310. Yes.
Shifted votes. 45,567. Those who are residing shifted. What has happened? Some voters residing in that same constituency shifted to some other constituency or some other addresses. That is 45,567.
45,000.
567.
So what is the total then?
Total is 113 again. 1,13,310.
So this total is 1. This includes 45,000 votes shifted, right?
Yes, including all.
Yes.
So total number is 1,13,310 votes, Lordships.
So this is in the list published on 410.
Many, yes, Lordship.
Because he has he has told
Yes,
no,
yes,
that
no.
list has been published on 4th
Yeah.
October. These figures, they are there from that list. 4th.
One small example I have given.
Ah.
That is in volume number 6, Lordship. Volume number 6.
No, we are asking.
That's what I'm giving the
1
answer.
minute. From 4th of October list also these names are there, right?
This is taken.
1 minute. We have to writing your submissions. First of this thing, 4th of October, which they have published the list. In that list, only also these discrepancies are there.
They have removed namesake, few names. Large number of names are still existing.
No, so how many? Like you should tell us.
That-
Because according to you, we should undertake this exercise of the revision of electoral rules under Article 226. You must tell us whose name has been deleted. How many people?
For giving exact figure, I have to cross check and I bring again the same data, what is available as of today. Because only one I have obtained yesterday night from my internet.
It
No, no,
is still existing.
You understand, right? What,
Yes, I
like
am.
what context? I mean, factually, you should be sure. He said that the list has been published on 410. Nobody can say, he even cannot say that the list should contain the name of dead people, bogus persons. Nobody can insist. The election has to be free and fair. But the question is, therefore, we want to understand whether in this revised voter list, according to this chief electoral officer, whether these names, according to you, are still there. These 1,13,000
Yes, in
still
order,
there.
in order to prove my case, I have filed only one. Yesterday night I have taken, still it is there. So many numbers are there. So I have to take out the printout of all this available.
No, so we will, this discrepancy continue. We will record, yes. Continue notwithstanding this thing,
Yes, continue.
41023.
Even
So
after,
what else now? So then what is your submissions? What are your submissions?
what are the,
Under submission, what are your submissions? Power under 22(3) can be exercised anytime.
what is my concern?
So then, 1 minute, then what is the relief that they should undertake the work of revision of
Yes, they
rules?
should verify, undertake the revision work and done the thing properly
Undertake the
and file compliance report.
work of revision. So this court is super chief election commissioner, right? So right.
What is my fear?
Lighter vein, Mr.
Yeah.
Don't be so serious, nothing, right?
What is,
Yes.
small submission, what is my fear? On the last date of this, if they do not remove, again I'll be standing as.
You will lose the election. But why should be so pessimistic, right? Don't be so pessimistic.
After a lengthy research.
Who knows?
After a lengthy research, if this name has been removed, I'm guaranteeing this vote I'll be winner.
We don't need any guarantee. We don't need any guarantee.
Long struggle.
Lighter vein, we said, Mr. Whatever said, we are not concerned with the result of election. How are we? Yes. That's it. Anything else? Fine.
That clears the lordship and permit I am filing the include petition, my lord.
Complete petition.
I am a affected party in this case, my lord.
Huh?
I am a affected party in the case, in this case.
No,
Total
no.
survey number is going 26 acres, my lord, earlier 2013 by
Which
the
case item?
9 millions.
Ah,
This is regarding to the.
yes. Don't, mister, you are, there is nothing, this is a public interest litigation. Sit down. Sit down. There is no intervention. We are dealing with the issue. Nobody as a party, you file a fresh writ petition, do whatever. This is a public interest litigation where, mister, you are the real culprit, not this thing. You told us, we remember that you told us that I have notified the full tank level and this thing all has been done. Where is the notification?
Yes, Lord, this matter I am not appearing because earlier I filed a petition.
You are not appearing, right? So then sit down then, yes.
That's why, Lord, my name will be deleted and that's why, Lord, that effect, Lord, I am here.
Yes. Yes, mister. Who appears for HMDA?
HMDA, my lord. Madhavi Devi, my lord, not appearing. by-
Show madam,
Madhavi
name of Madhavi Devi. Yes. What affidavit you wanted to file some affidavit? Have you filed?
Is notified on.
Notified. So, mister, now no excuse.
Yes, sir. We have already
In
started.
2016, we have written, it has not been notified full tank level. Therefore, I can't do anything.
Now the preliminary notification has been issued, my lord. We will take.
There is no question of preliminary and final measures. This is not a land acquisition proceeding. Don't, mister.
We will fence.
Is it a land acquisition proceeding?
No.
We are, we are concerned with fencing of
Yes,
this thing. Don't make out this thing.
We are.
Excuses,
to
fine.
fence it, my lord.
New excuses that
No,
it's a
we are not-
preliminary notification now. Therefore, now final notification has not been issued. I cannot fence the
No,
area.
but we are undertaking to fence it, my lord, entire. In the report also I stated so.
When? Tell us when. When will you fence the area?
But page number 2, my lord.
That is date. Page number 2 means.
We can,
Ask him.
because as per the FTL fixing, my lord, after fixing the FTL, we need
It
to.
has been fixed, mister.
No,
That is
they
the-
issued a preliminary notification calling objections. Within 30 days, my lord, they will issue final notification because it's a patta land. Some third parties' interest are there. It's a purely private patta land. So that is the reason, my lord, we are going to.
No, this is Mr. Deseal the water body.
Yes, my lord, that
In
for,
this-
for which, my lord, we are.
This,
ready.
all this, they don't need any time, right? I mean, like,
No, no,
the water
the rest
body,
of- rest of
nobody
all
will
which we
go
are
there
going to-
inside claim.
The rest of all, which we
In
are.
case he claims to be a private tank, even assuming, then even if you desilt, he will be benefited.
Yes, that part, my lord, we are taking, so that is the reason, my lord, we made.
Supposing if pursuant to objections, they hold that it's a private tank belonging to somebody. You are
Even
worried
then, my lord,
about it.
Even then, my lord, for which also. my
No,
lord,
we
are-
will see to it that if it is declared, then he will
Even for private,
compensate you. for-
even for private patta also, my lord, we initiated land acquisition proceedings through issuing TDRs. Most of them were received and
No, mister, this 3 directions, mister, they have to be complied with in a
yes.
time bound manner. First thing to fence the area,
yes,
tank,
we-
desilt the water body, increase its water holding capacity, and this plantation in catchment areas to stop soil erosion and desilting of the tank.
yes, my lord,
This
we
has
will
to be
comply.
You tell us the time limit.
But 8 weeks time may be given, my lord, because of election code is there, so that is the reason. 8 weeks time may be
The
given.
election does not prevent like
Yes, the
fencing.
work will go on, but we will file final report after 8 weeks.
You let him make a statement. So we are recording a statement who is present in the court that he will fence the tank in question.
Yes.
You will fence the tank in question. Desil the water body, desil the water body and undertake the work of plantation.
I mean, please. Thank you, sir. So this regarding the fencing, sir, totally, as per the preliminary notification, we have surveyed 1871 meters is the fencing we have to do. Already 400 meters of fencing we have already done. Remaining 1871 meters, total perimeter of the FPL, preliminary notifications. In that already 400 meters fencing already done by the JHMC earlier.
Yeah.
So remaining 1471, we are preparing estimates now only, we'll keep it ready. We will not wait for the final
This thing
notification.
we want to see, Mr. We are not concerned with estimate and all that. We want to see that this area is
Absolutely, sir.
before next date of hearing. You do whatever it
That's
takes.
because we cannot sanction any estimates before the final notification. So that's the only thing. We are only waiting for the final.
Why
notification.
final notification? Oh, you are waiting for whom?
Once the notification is issued, whether,
Huh?
once the notification is.
Where is the notification, preliminary notification? Huh?
Yesterday's 11th.
11th notification.
11th is notification.
Where is the 11:10? Affidavit. Hmm. Full tank. This is blank, Mr.
Here in the
Yeah.
outside manner, convener late production company.
Map above on or before 5 PM on dash 23.
30 days
day?
time,
Huh?
30 days time.
Who will fill in the blank?
That is built up in the main copy manner. It is only.
Well, what is the copy? Tell us date.
Thirty days time.
No, when this notification has been issued?
Yesterday. Yesterday.
11:10.
11:10. 11:10:30.
No, so on that basis, Mr. you act upon.
Sure, sir. In meanwhile, I also undertake no enforcements will be permitted in the 30 days.
Ah.
I'll put enforcement. I'll ensure that nobody gets into that, sir.
Yes.
Second thing regarding desilting also, we are preparing the estimates. Keep it ready, sir. As and when the
No,
final
2 months you do it, Mr. And you
only
appear.
more request.
No.
Election notification has come, sir. So till December 5, I cannot issue any fresh sanctions. I'll prepare the estimate. I'll send it to the election commission for relaxations. Once I get the relaxation, I'll go for tender, sir. It's a genuine issue, sir. Please consider. Because on the election, I am not supposed to sanction any new ones. But I will definitely send it for relaxation, sir, once it is ready.
You said what is
Yes, sir.
this? Is a
It's a public work. They can consider, sir. I'll send it to the election commission. So that's the only request I have. Third one also, sir, plantation and beautification already 1.6 crores.
desilting also you cannot do anything.
Sir, till the time FPL is finalized, I will not be able to do anything, sir.
No,
I'll prepare the estimate and keep it ready, sir. That's the thing, sir. I'll undertake it, sir. Definitely. I will.
So why you did it, Mr. Yesterday only? 2016 the proposal was sent to you, right? Why you did it like
But that the proposal is not sent by we on our request. to-
yesterday he told us, I mean last date of hearing he told us that in 2016 it was sent to Revenue Department.
Revenue department, but this notification is given by the late production committee and HMDA Mellon. This is done by the, that's what Mellon yesterday I brought to the notice of this.
You are appearing for HMDA.
I am the government Mellon, I am appearing for the Secretary Municipal Administration. Not responded, and also I in consultation with the Municipal Administration Mellon, this the work done is Mellon, yesterday itself we asked him to notify.
You are representing HMDA also, right?
Yes, right.
Huh? So Mr.
Sir, third one is regarding plantation and beautification. Already 1.6 crores sanctioned work is going on, sir. We'll continue with the work. This work is for the one portion. The remaining portion also, I'll prepare the estimate and keep it ready, sir.
Plantation is going on.
Going on, sir.
How do you
Plantation and
plan,
beautification
like
on the
tree
bandage.
guards, tree guards.
And sir, whole fund we will ensure that both sides plantations are there, sir. Including tree guards, everything we'll keep it.
Yes,
Fourth one, sir, you have also requested for drainage diversion. The drainage should not enter into the sewage. should not
that
enter
you
into-
can see, that you can do, that does not require permission of election commission.
Yes, sir. So, but what will be done by the water works, sir? We are in touch with the water works. We both did an inspection also, sir. And we will do it, sir.
That's your statutory duty, right?
That will be done by other departments, sir.
For that you don't need permission, anybody's permission.
Submission, sir. That will be done by water board department, sir, not by GHMC. But we both were coordinating and we did it. We did a joint inspection. We have identified
Who will do it?
water board, sir. Metro water and sewerage board is there for it, sir, separately.
Sewerage board is there, Bernard. The commission.
We are in coordination.
You undertake, mister, to do it.
We already inspected the.
This is all for future generation, basically. That's what it is, not an adversarial litigation. Yes.
And honorable court also requested for cleaning of garbage and other things. That also we have done it, sir. It will continue to be done, sir. We have sent some
Now
photos
we are,
also.
yes. In compliance of the order dated 20
Your Lordship may dispense the present.
No, so he has to file but compliance report
Yes, my lord, we will file it.
uh, uh, for the requirement of.
My lord.
Okay. So crusher unit
My lord, we implemented the
completed.
absolute.
Mr. What is the representation? The grievance is only for consideration
Yes,
of
my lord.
representation,
The representative, just not the papers, my lord, but it's for the direct.
right? Mark the presence with consent of the hard. Seven to 23, whatever. Yes.
Your Lordships, and this matter, appellate counsel is not well, Your Lordships. He requested this matter to be taken up next week, Your Lordships.
This is admission, madam.
Yes, Your Lordships. He has filed an incomplete petition also, but he's not well, Your Lordships.
Learned counsel for the appellant.
That's okay. They said they would file a counter, but my AOR says no counter was served on him.
My lord, I am appearing for appellant counsel, my lord. We are filing reply for the objection petition, my lord. Today we are filing, my lord.
Reply to
Objection petition. Yes, my lord.
how much time do you need?
Today we are filing, my lord. Kindly have it next week, my lord.
What this is rate appeal? What counter?
Reply we are filing, my lord.
Not they have filed counter for that, we have filed reply.
Learned counsel for the appellant pray for.
12 and 13. Both night.
Huh?
12 and 13, madam.
12. Yes. Yes.
May it please.
What is the early date?
Fix, yes, my lord, sir, filed a petition for fixing an early date.
We consider it later on, Mr. Not now, next year sometime. You see, we are dealing with 2005 rate appeals. So hopefully by the sometime it will be this.
My humble request, if at all it subject to lordship's convenience in November.
Appeal is, petition is admitted for hearing, let IA number. Yes.
My lords, there is a, in fact, this is part of a batch of matters, my lords.
Give the number list along,
Yes.
along with so and so, right? Give the.
I will, my humble, I just renew my request for November, if subject to your lordships.
December last week, they will consider. See, there's no justification. Prepare a synopsis if you want it to be heard early. Assist, not like petitioner was born on 15th of August 1947. Don't start like this.
We have a synopsis is ready, my lords.
No, we are telling you the ways and means to, like, it will be considered in last week, December. Yes. Yes, Mr.
The lordship wanted me to explain as to how the writ is maintainable in view of availability of an alternative remedy by way of an appeal to NGT. But this is a pollution control matter, but my humble submission before your lordship is, it's a straightaway challenge, not based on my right under Article 21, because these are all bulk drug industries, which are creating a lot of pollution in the area. And as on the, just 3 days back, I read.
See, one option we are telling you, we can, if you have made any representation, we can direct the pollution control board to act on your representation after hearing these people.
That is fine balancing of the interests of the parties, but I
No,
just.
no, we did not say, not in this case, Mr. There is no, there is a direction to file the status report. There is no direction asking you how petition is maintained, not in this case.
No,
We don't know. Because see, your grievances with regard to inaction on the part of pollution control board.
Exactly.
Right? So have you filed a representation?
Actually, the.
Have you filed or would you like to file?
Yes, I would like to file. I would like to file.
All right.
Before that, if I'm permitted, I just want to say something, Miller. The pollution control board is understaffed. Actually, the problem is arising because of the.
He is not saying. He is not saying. They will decide your representation within the time limit which we see.
As of now, twice, Miller, these industries have been punished.
No.
The way of imposing fine, they pay, and sometimes they don't pay. They get some order, but the pollution continues to exist over there. Just
We are directing them to take an action at the first instance, right? We don't know. The other option is to give them time to file a status report. Choice is yours. What do you want?
I go by what you say, your lordship would say. I just thought that I would just bring to your lordship's kind notice that just 3 days back I went to the area because my client's mother died. We were there for about half an hour. The order that emanates from these industries is such harsh. We can't stay there even for a half an hour's time. You get breathlessness and the skin gets itching sensation, and it is such a horrible condition. Rather, my client requested me that if an advocate commissioner is appointed, rather.
No, so you make up your mind. We will ask them to file a status report.
No, they have filed a status report, Mulad, as on today. It is there before your lordship, Mulad, where they were trying to tell this honorable court that they have been acting in accordance with the law, and the errant industries have been fined twice or thrice. But that is not making the matters better.
With your Lordship's permission, my lord, we have filed the report stating with respect to the status report, my lord, multiple representations have been answered on multiple different occasions. And as of today, with respect to the permissions
No,
also.
no, but you have imposed fine on them.
Yes, my lord. Fine also has been imposed as recently as September 2023, my lord. An amount of 24 lakhs bank guarantee has been forfeited, my lord.
No, but perhaps that is not the solution, right? It's not being enforced. So what do? We will issue notice then to them. In view of the status report. Personal notice to service.
We may
That
take
is there.
personal notice.
My pleasure. This petition is filed by petitioner.
Last occasion, Lordship directed to counter affidavit, I filed last occasion, Lordship directed to sign a counter affidavit, I filed a counter affidavit. It's no industry, mixing plant is running, they are not started.
So you want to file, you have filed counter?
Yes, but I filed, I have eighth respondent, but pollution control.
The Lordship sorry, Madam. Your Lordship directed the member secretary to file an affidavit as to why the representations filed by the petitioners have not been considered for withdrawal of the consent order. Pursuant to that, they filed an affidavit, not counter, Madam. They stated that the company, the industry has not been started work, Madam. Your Lordship kindly see the photograph.
Not like this. You have to place it on record, right?
Just
after supplying a copy. You can file a reply to this affidavit or rejoinder, whatever. Counter affidavit. Learned counsel for the petitioner. You in piecemeal, we are not going to remember it.
No, Madam.
If you don't want to file counter, please argue. We will decide it today itself.
I'll file, my lord, because before that I want to bring some information before your Lordship. Because in spite of the notice issued by the HMD and Gram Panchayat, he is constructing the industry without any permission, my lord. That is my grievance, my lord.
A request is made to cancel the CFA granted by the board in favor of the unofficial respondent to establish a cause. It's mixed unit. That is their
Who
request.
appears for
But I'm
respondent?
waiting for the 9th respondent.
What?
But I'll-
You are very quiet and this wholly not getting an opportunity to speak, right? Please.
My lord, Lordship may kindly see, my lord, the prayer and the present writ petition, my lord, for my lord's
This
consideration.
all here, Mr. Writ of Mandamus. So I fail to understand how writ of Mandamus can be sought for inaction. I don't know what goes on here. See,
My lord, this writ prayer,
Mandamus
my lord,
declaring action in not considering representation.
my lord, earlier also, my lord, page 53, my lord, the earlier round of litigation where the same writ petition was filed by the same party. At page 53, may I request, my lord, same prayer once again is sought in this writ petition also, my lord. The earlier writ petition was disposed of, directing the petitioner to approach the pollution control appellate authority. My lord, verbatim, everything is same, my lord. The second writ petition is not maintainable, is my respectful submission, my lord.
My lord, your Lordship kindly page number 64. I have pursuant to the orders of the Honorable Court, I filed an appeal before the appellate authority because the tenure of the appellate authority is over by 5/8/2023. And SR, I have mentioned the SR number also, man. I have filed the copy of the appellate.
Where is the petition, where is the averment that appellate authority you filed an appeal,
madam.
previous petition?
Yes,
Have they disclosed this fact?
madam.
Paragraph 10, my lord.
10.
Paragraph 10, I further submit that in compliance of the order passed by the Honorable Court in WP number so and so, the petitioners have filed an appeal before the appellate authority by SR number so and so dated 31/8/2020.
Disputing that, my lord. The prayer, my lord, which was
Therefore,
sought. But the prayer
the fact is that they cannot be said to be guilty of suppression of fact.
My lord, I am not saying
So
that.
then this
not
thing
saying
and
that,
the
my lord.
appeal of the tenure of appellate authority has come to an end, right? That is also correct.
But I'm
You
not.
file counter, whatever.
Yes, my lord.
Learned counsel for respond number 9. Praise warrant is granted. How much time?
Lord, 3 weeks, my lord, my record.
3 weeks time to enable him to file counter. In the meanwhile,
Please,
Mr.
sir. Yes, please, sir, ready and file it today, my lord.
Today.
Yes, I've received details yesterday.
Okay, learned counsel for the
Monday,
petition.
my lord.
In fact,
Monday
it has
takes to
become,
file.
it has become infectious. 30th September is the last date for admission into MBBS courses. But
We'll
these
see
are
what. Let him. Learned counsel for the petitioner. Praise for adjournment to enable him to.
Constitution of Financial Commission, Finance Commission. Some more time is required. The code, election code, no. The file is already circulated to the governor. The proposal.
Learned senior counsel for
19
the petitioner submits that the file has.
Yes, they have filed an application for fixation of a date month.
Who? They means.
IAF, but the
They
government.
mean- Government has filed.
Yes.
What?
Including petition.
No, no, there is also IAF, which is for fixation of it.
IA4. Complete petition.
But the past signature, past this dates. IAF is. IAF is fixation.
What is, who is the complete petition? Who is?
Implead petition, I have also filed, they have also filed implead petitions. They may be ordered and the date may be fixed.
All right.
The date may be fixed.
My lords, as per the implement of A.R. Srinivas, my lord, the gentleman is transferred, my lord, recently. That also may not be required because that particular name.
But if he is heading the sit, he is necessary. If he is not heading the sit, his presence is not necessary.
He is not heading, my lord, and he is on
Not
spot.
heading. You find out after this thing,
Yes,
after this
after vacation.
vacation.
Yes.
Yes.
Learned counsel for the petitioner prays for adjournment.
Petitioner is applied, he tried to appeal for this.
IA, what is IA?
I
To withdraw the amount.
But I do not have any objection on it. Insofar as my portion is concerned, I have already.
So heard on IA number 1 of 2023 for the
May I please? Fixing of early date IA number 2 of 23 is 5 minutes. The writ was admitted on 16/8. Contesting respondent filed counter. I have filed a rejoinder and synopsis also I have filed. This issue is dealing with the enhancement of reservations to the scheduled tribes from 6% to 10%. Thereafter, the breach of 50% limit.
we'll consider in the month of July. Let IA2 of 2023 be listed for consideration in second week of January 24.
Obliged.
May I please, my lords. Let's have prepared a synopsis minutes. Can I pass on minutes to your lordships? There is one fact which I have to bring it to your lordship's notice.
Anything
Mr. Vijay
surprise,
Kumar is, Mr. N. Vijay, his name is cleared by the Honorable Supreme Court's collegium. That's 10th minutes, 10th of October. 10th of October. The other side counsel's name is cleared by the Honorable Supreme Court's collegium for elevation.
He is representing respondent number
He is
5 to
responding,
9
he is representing the respondent.
in this matter.
Sir, in your, in the brief note, what you have given,
Well, it's,
appears that already the land has been taken over, its possession has been handed over.
well, possession is
Anything
granted.
further survives.
No, well, it's only some part of it is granted, but it's not all, the entire part. Well, the entire land assigned was 3 acres 26.
Taking illegal possession. The action of taking possession is under challenge, but where is council can appear, right?
Well, it's I thought, well, if I argue, then I don't I have to begin.
Logging through. He is logging through WebEx, my lord. For respondents, number 5 to 9, my lord. My senior is he's trying to log in through.
He is logged in. Yes.
Well, it's
Yes, Mr. Vijay.
Yes.
He is there.
Yes, yes, I'm here.
Yes. So you are questioning the action of your disposition in a writ petition.
yes, well, it's-
So that's what learned Singhal just said, that perhaps.
well, the learned judge, well, it's said that well, the order was not filed. Now, well, the order is there before your lordships. Well, the even the count.
Order is not. No, remedy is to approach the for recovery of possession.
Well, it's a case where well, the possession is given by the assistant director of settlement, survey and settlement after conducting a survey. Well, he is not authorized.
Where is the order?
Well, the proceedings are filed by the counsel for the respondent along with the counter minutes. Initially, if your lordship looks into the counter, para 12, there is an admission. Then the various proceedings referred to in para 12 of the counter are filed. The para 12, one of the proceedings is dated 5/1/2009.
Where is, which page?
Para 4 of the counter minutes, page 12. That's filed by the unofficial respondent. That's dated 24th of April 2009.
Four. That's
It appears to be in an interrogatory application.
Affidavit filed by respondent number 4.
To 9.
That is official respondent. He is referring to private.
Private, that's 5 to 9.
So, madam, is it so that while ordering survey, he has handed over possession?
My lord, what has happened is two parallel proceedings are going on, my lord. Once, when the government has resumed the land and reassigned to the
No,
respondent,
you understand, right? Like an authority which carries on the survey cannot direct delivery of possession. If it is so, end of the matter. Otherwise, then if there is a dispute with regard to facts, then we will be.
he has not arrayed us as the party respondent to the suit, my lord. We are not respondent in the suit. It's
No,
going
not-
on between both of them.
Not suit means the grievance is what he has argued is that while carrying out the survey, the authority has directed handing over of the possession. That can't be done.
That cannot be done, my lord.
That's what.
Yes.
The answer is simple. That's why we ask you.
Yes.
If that has been done, you also agree it can't be done.
Survey department has directly, without drawing a Pachnama and without surveying, handed over. That was questioned by the private respondent, and that has come as a petition in the writ petition. Well, what has happened is we
That
have
has come-
the land in
No,
1968.
no. So, madam, the authority which carries the survey cannot direct delivery of possession.
Yes.
You should have let the parties to take recourse to the remedy of civil suit. How can you take possession from one party and hand it over to the other? That is the simple case.
That's what is the single judge's observation, my lord, wherein it is stated that they have to go before the appropriate court.
No. You will burn his house, right? And Tahsildar survey officer will go and burn his house, and then you will say for damages he must go civil court. You must justify what is the under which provision of law the extents what survey officer has handed over possession. Then we will ask him to go to civil court.
My lord, a
But you
petition,
cannot this thing.
I understand, my lord, but here what has happened is the government was
But
not.
why are you siding with respondent? What is why are you siding with, it's a dispute between two individuals.
Yes, your lord.
Then why are you siding with respondent? You must take a neutral stand, right?
The government stand is, my lord, in 1968, the land was assigned to the appellant before the court, my lord. And because of the violation of the patta conditions, that was resumed in the year 1980. After resumption of the land in 1980, my lord, they have not challenged the resumption order.
See, madam, the order passed on. She may not be aware. Please see.
Minutes.
24th January 2012 order.
I'll look into it, minutes, sir.
No, but usually assistant survey officer and
Minutes, deeply obliged minutes.
How can they, Rishi Gandhi, you ask her, how can you take possession? If you know it is part of the ask her how can. No. Ask her. She will report it. Must restore the possession to this people. The assistant survey officer, if he has no jurisdiction to hand over possession, the party should be invested. The legal wrong, right? Once he is citizen. So Tahsildar must restore possession and the rights of the party shall be worked out in this way. Okay, can't Tahsildar cannot direct possession. How can he take over possession? Ask which authority, which provision Tahsildar is empowered to take possession.
Council, under what provisions the Tahsildar is empowered to take possession? There was only a direction for survey.
Yes, your lord.
Subsequently, the possession was taken by the Tahsildar.
And-
Your lordships are referring to the order of 24/1/2012,
Yes.
your lordships. After this, there is another order.
No, if there is an interstate dispute, they have
Yes,
to
sir.
work out the remedies.
Yes.
You cannot ask which provision. So which provision Tehsildar can take possession and hand over to the other party? Madam, answer
The
simple.
Tehsildar has not taken, my lord. The survey department has conducted.
Whosoever.
So
Survey is also your employee, right? Survey
this
department.
revenue department only, my lord, no dispute. But here is the position where.
Can't this.
Yes.
What were you referring to?
Minutes para 12 minutes at page 4 of the counter affidavit filed by minutes, the unofficial respondents minutes. That's dated minutes 24th of April 2009 minutes. That's in a WAMP minutes. May I read the paragraph 12 minutes. Here they admit minutes that the assistant director of survey has conducted the survey and he has taken possession and he has handed over the possession to them. And minutes they filed the copies of those documents as well.
So 1.20 guntas, right? Of survey 103. That you are entitled to.
Minutes. Minute, may I submit to this minutes? The entire land that was assigned minutes to the appellants, minute was 3 acres 26 guntas.
No, correct. But this 1.20 guntas of survey number, this thing, the possession was taken by assistant director.
Minute,
That
yes.
can be directed to be
Minute, whatever the redirect, only a lot.
only 1.20. Yes.
1.38 minutes.
No, it says para 12 itself. It's a 1.20.
1.38 minutes.
Erroneously delivered, therefore
1.20,
delivered land
stand corrected.
to the petitioner and land is only 1.38.
Obliged.
Yes,
minutes, I'm obliged. It's 1.20.
1.20. All right. Yes. Yes, Mr.
Minutes read.
Ask. Two step. He is looking at me.
Oh, sorry.
These
sorry.
things are. Achha, sorry. Yes, Mr.
Sorry.
So this thing in the garb of survey, the possession of land could not have been taken.
One fact, there is a lot of civil litigation between the parties, starting from 1980.
No, we will confine this C. We will confine the order only in respect of 1.20 and clarify that the rights, question of right party in interest between the parties shall be decided by adjudicated by civil court, if any, if OS is pending or appeal is pending, whatever.
One aspect, my lord, if your lordship will see, it's an I just narrate, my lord, what my
as we have understood, the only grievances this thing in relation to handing over a possession of 1.20 guntas of the land in the garb of survey. That's the only contention raised.
I understand this, sir. I understand my friend's point. The land, my lord, even by the writ affidavit, my lord, at para 2 of the writ affidavit is an assigned land, my lord, back in the year 1968. It was assigned, my lord, on certain conditions to the writ appellant. My lord, it was assigned, my lord, to the writ appellant. And, my lord, the government counter, there was a suit, my lord, for recovery of fortune against this unofficial respondents. That was, my lord, the suit, my lord, and continued for a certain period of time. The government, my lord, counter, if your lordship were to see, filed in the writ petition. Lord, what they say, my lord, in their counter is that the land was, the assignment was cancelled in the year 1980. And, my lord, it was reassigned to these unofficial respondents. My lord, if your lordship were to see their counter, my lord, which is at para number 4, the my lord, of their registered counter. In fact, they even a tabulated statement also. May I read?
Counter of which? Whose
Counter of the respondent number 1, my lord, in writ petition.
Respondent number 1.
Para number 4, my lord. The other one aspect of the issue, my lord, is that the government is not a party to the civil suit, my lord, which was filed for declaration of title and for recovery of possession.
No, that will be gone into like in the civil suit. We are only,
I'm only trying to, as a matter of fact, my lord, I brought it to the lordship.
yes.
What they say here, my lord, it is submitted that the writ petitioner has repeated the observations made in judgment in EP 11 of 2003 by the Honorable Judge. Your lordship got it, my lord? Para 4.
Yes.
It is submitted that the writ petitioner has repeated the observations made in the judgment in EP number 11 of 2003 by the Honorable Judge. The points raised and answered therein are far from the fact. As stated in para 3 above, the writ petitioner has contravened the conditions of Form D Patta, and the same has been cancelled in proceedings number D4 5674 dated 25/1/1980 by the Joint Collector Nizamabad, who is the competent authority. In pursuance of these orders, the position from the petitioner from the purchaser was resumed by then revenue authorities, and the land was reassigned and patta certificates were issued to the following persons shown against them and implemented in the revenue records. Not these are the unofficial respondent. The writ petitioner had contravened the conditions of Form D Patta, and he will forego his rights over the land. Hence, the Patta certificate issued was cancelled by the competent authority duly following the procedure. The land has been assigned in favor of the eligible persons as per the rules, and there is no malified intention attributed to the revenue authorities. It is submitted. My lord, it's a short counter. I'll complete this. It is submitted that the writ petitioner has filed AS 778 against the decree in OS 8 of 75. In fact, the decree did not come into force since the writ petitioner was not in possession. The assigned land in question was cancelled by the competent authority and resumed. Later on, the land was assigned to the persons shown in para number 4 above. The writ petitioner was put in possession on 29/4/2004 in survey number 601/2 to an extent of 3 acres 26 quintas under the cover of Panchanama by the bailiff of the senior civil judge Kamareddy as per orders. The subsequent assignee is still in possession of the land, and OS 58 of 2003 filed by the assignees is pending in the court of Honorable Civil Judge Kamareddy for declaration. My lord, one aspect, my lord, is that the cancellation of his right, my lord, is on the basis of a assignment granted in 1968. That assignment, my lord, stood cancelled in 1980, and it was reassigned to these individuals. My lord, our submission, my lord, without going into the details of the civil litigation between the parties, is, my lord, once he has lost the right over the land, his right, my lord, emanates, my lord, from the assignment. Once the assignment goes.
When was it assigned?
1968, my lord. If your lordship were to see the writ affidavit in para 2.
And when it was cancelled?
1980. 1980.
80.
Yes.
1980. My lord, the dates were also given. 25th of January 1980.
My lord, and 1985 it was reassigned.
25th of January 1980 it was cancelled. My lord, para 4, my lord, it is mentioned, these dates are mentioned.
No, but how could, I mean, it's cancelled, but under which provision possession has been taken back? With that point, we quite see that he has no right. But how possession was taken back?
The position, my lord, the government counter says, my lord, that the assignment was cancelled. And my lord, the position the land was resumed is what they say here in their counter. My lord, at that point of time, my lord, going by parallelly, my lord, if your lordship were to see the civil suit, my lord, it is these unofficial respondents who were in possession of the particular property. And because it was on the basis of an agreement of sale which was executed, my lord, by the writ appellant. And since we continued in possession, my lord, land was reassigned to us in 1985.
What happened to this order dated 25th January 1980?
That attained finality. It was not challenged anywhere. That's what is their counter.
Yes, Mr.
Minutes, can I explain to your lordship this minutes?
Once
Initially,
Yes, yes.
I'm sorry.
Anything else?
Once he has lost his primary right to the title of to the land in question, my lord, he cannot ask for a relief, my lord, before this court without challenging the assignment which was cancelled. Once it is cancelled, my lord, it goes to it vests with the government. And his position, my lord, he cannot have a right of, see, end of the day, my lord, in a writ petition, his right has to be established. Once his right is lost, the primary right is lost. But he may not be entitled for any relief as such.
No, that's it. Anything else?
No, I'm obliged.
minutes, I have to narrate to your lordships the civil litigation minutes. Initially,
Whatever, I mean, this
the
fact.
reason is this minutes.
No.
The cancellation, whatever.
We will go through everything, but 1968 it was assigned, 25th January 80 it is cancelled, and that order has attained finality.
No, Millets, that's my submission to your lordships. The reason is this. Millets, initially a suit was filed in the year 1975 against Millett, the unofficial respondents, for seeking a declaration and possession. Millett, the suit was decreed, it attained finality. When execution petition was filed, the unofficial respondents filed an application under Order 21 to 97 claiming that my patta was cancelled and that Millett, they were given a reassignment. Millett, the trial or the executing court gave a finding that there was no cancellation and there is no reassignment, there is no patta in their favor. Millett, against which Millett, they preferred an appeal. Appeal was dismissed, against which they preferred a second appeal. Second appeal was dismissed, against which they preferred a leave to the Supreme Court. The matter was dismissed. Millett, subsequently, Millett's second EP was filed. Millett, in that EP also, Millett, the court felt that Millett, it is res judicata. These issues were already decided that there was no cancellation of patta and there was no reassignment in their favor. Millett, that's a finding which has been laid down up to Millett, upheld up to Supreme Court. Millett, can I show you lordships the findings, Millett, of the executing court, Millett, the appellate court, and this honorable court, Millett? Millett, that has become between the parties.
This suit it was held that your lease has not been cancelled.
Pardon me, Millett?
Your lease was not cancelled. Your patta was not, this thing assignment was not cancelled. Where it was held?
That was in Millett, EA 58, Millett. That your lordships started.
No, you filed a suit for declaration in possession.
Millett.
So what it was decreed?
Decreed, Millett.
When?
Millett, the suit was decreed, Millett. Millett, it was decreed, Millett, on 22/4/1978, Millett.
Then what happened? This appeal, etc.
We have filed an appeal against Millett, AS 778 of 1999, Millett, whereby we were directed to repay Millett about 5,500 to the unofficial respondents. To that extent, Millett, we were agreed. Millett, declaration was given, possession was ordered, we were directed to repay Millett 5,500. Agreed against the order directing us to pay 5,500. Millett, we filed an appeal. Millett, appeal was allowed, and Millett, the order directing payment of 5,500 was set aside. Against which Millett, the unofficial respondents filed an LPA before this honorable court. Millett, the LPA was 104 of 1983. Millett, it was allowed on 13/8/1987 only to the extent of the order directing the payment, setting aside the payment of 5,000 rupees. Then Millett, after the order has become final, then we filed Millett's EP 4 of 1983. Millett, the EP
in the EP, they filed, my lords, an EA, an execution application under order 21 rule 97. My lord, contending that, my lord, the patta granted to us was, my lords, cancelled and they have been reassigned the patta. My lord, the executive court disbelieved it. Can I, my lord, take your lordships to, my lord, the order where, my lord, the executive court disbelieved it, my lords. That's at page 78, my lords. Minute page 77 minutes, I'm sorry. Please come to minutes, para 2 minutes at page 77. Let the, um, about 7 lines from minutes from the top at the para 2 minutes. Says when the cancellation of the patta, has the lordship got it or shall I read the entire paragraph? When the cancellation of the patta in favor of the decree holder is not established, the further assignment of the land in favor of the objectors, that is son of the judgment debtor, cannot be valid.
Utility model you are showing here. It says that parties have no objection.
Then minutes, page 79 minutes.
See, Mr. In terms of you had agreed virtually few minutes ago, we need not go into all this. You had agreed for handing over possession of 1.39 acres. Right? They have no objection.
I
have recorded in the order sheet. Will this thing not necessary to worse?
The reason is if your lordship gives them liberty, whatever the rights that are already decided, well, it's up to, well, for the last
No, not
20 years.
liberty. We will direct handing over possession because they don't have any objection. Right, Mr. Mr. Vijay, you don't have any objection to handing over possession of 1.38 acres of survey 10601.
I understand. My lord, the earlier proceedings, my lord, I cannot go back
No,
on.
no, this 24th January, this fact is recorded, you have no objection. That's why we are going into merits.
Yes. One aspect, my lord, what I wanted to bring about with regard to the findings at page 77, which my friend read, not the government is not a party to the civil suit.
No, we are not going into the merits like this is what the order is. Right? This intra-court appeal is filed.
para 2 of this writ affidavit, my lord, the land is an assigned land. There is no dispute to this fact. Para 2 of his writ affidavit speaks of the fact that it's an assigned land by granted back in 1968. So
Yes.
civil court findings, my lord, may not come to this help as regards, my lord, the possession part. His right to the particular land is concerned. Because it was more on a bilateral issue where there was an agreement of sale under which possession was taken by these unofficial respondents. There was a dispute. This dispute ended in favor of the writ appellant. But that does not, those findings, my lord, and the observations which have been made in the civil proceedings, my lord, did not bind the government through which, my lord, the possession and reassignment was done in our favor.
Yes.
That's all.
Millets, the government may not be a party, Millets, but the unofficial respondents who claim that Millets they have been assigned the patta, Millets are parties. They claim that Millets they have been assigned the patta. Millets,
No, but there is this order, 25th of January 1980 has been declared to be null and void, whatever. Where the validity has been adjudicated. The senior counsel has pointed out that this order dated 25th of January 1980 cancelling your this thing assignment in your favor has attained finality. Please tell us which court has said that this order has been set aside by which court? 25th January.
Please, please come to Millets, page 124, Millets, the appellate court order, where they said that the cancellation is invalid, Millets.
The assignment can be cancelled. He doesn't have any right. It is why the state order from the original report instead of doing it.
In the middle, Millets.
To be primary, until they see the report is happy that this order cancelling the DSP.
In the middle, Millets, it starts from, therefore, it is to be held.
No. So where have you challenged, Mr. Which proceeding have you challenged this order dated 25/1/1980? Please tell.
We have not filed any appeal or any other thing challenging it. But
That is the order.
But the subject matter, Millets, was in the execution petition. They said that Millets, my patta is cancelled, and that Millets, they have been reassigned a patta. Millets, they filed the assignment pattas before the executing court. But Millets, the executing court, Millets decided that Millets, there was no cancellation and there was no assignment. And then Millets, the cancellation, even if it is valid, it is held to be invalid because it violates the the rules. That is Act 9 of 1977. Millets, assigned lands prohibition of transfers act. And then Millets, they said that it is not valid. And that finding Millets was challenged in an appeal by them. The appellate court Millets upheld those findings. Held that Millets, there was no cancellation of the patta and no reassignment. And then Millets, that is upheld even by
no assignment means this was whose document 25/1 non-existent. What is it?
Millets, the lodgement
cancelled means whether the court, after taking into consideration the order dated 25/1/80 held that not considered. Government is not a party.
Government is not a party, but Millets, they filed the documents Millets before your lordships. Millets, they filed the documents.
Not a party to your civil suit, Mr.
Millets, in the civil court, Millets, the civil court's Millets, findings your lordship kindly.
Mr. We want to understand from you whether the executing court, I mean, we don't know, executing court, after considering the document dated 25/1/1980 held that it is no, such a document does not exist, it is never cancelled. Merely saying in the absence of the party that no such cancellation was made. How that this?
May I request my lord to kindly come to Millets?
No, you understand, right?
I do understand, Millets.
Yes.
I do understand.
So then what is 20? Where is you show us if it has? See, Mr. Long and short of it is this. If order dated 25/1/1980 stands, you may not claim. You cannot claim any right to continue.
Millets, please see Millets, exhibit V1 and V3. Millets, your lordship kindly see Millets. That's page 101.
No, please answer this query, then we will see whatever. Please answer whether it has been cancelled. this order has been set aside, 25/1/1980.
My lord, it was not set aside by, in an appeal. My lord, if your lordship.
Therefore, it binds you, right?
My lord, it was decided in the civil suit, my lord, saying that there was no cancellation.
No,
My lord, the counterclaim is filed under.
even if this order, even if this order is if the order is in existence, it will bind you until unless its validity is assailed by you. Order, it binds you.
It's a case where, well, it's the objection petition in the execution petition claimed, well, he made a foundation saying that, well,
You have already filed a civil suit, right? Civil suit is pending, no?
no, well, I did not. My civil suit is ended in a decree. Well, my civil suit was filed against them, well, seeking for declaration and possession of the property from them. Initially, they claimed that, well, I entered into an agreement of sale with them and I wanted to sell the property. Well, that was disbelieved by the trial court, and then a declaration was granted in my favor saying that I am the owner. Then possession was also directed to be handed over pursuant to the decree. I was directed to pay rupees 5,500 back to them. Well, that decree has become final. Well, in execution of that decree, well, when I filed an EP for execution of that decree, well, the very same unofficial opponents filed an execution application, made a counterclaim, well, saying that my patta was cancelled and they were reassigned patta. Well, therefore, it was incumbent on them to prove that patta was given to them and that there was cancellation. Well,
yeah, all these questions cannot be decided in a writ petition.
No,
was given.
I'm not asking your lordships to decide. Well, it was already decided by the executing court. Executing court found that there was no cancellation of patta.
But these persons are not parties, right?
The unofficial respondents are parties. That is binding on them. The unofficial respondents who claim that my patta was cancelled, that is their pleading. That pleading was negative and that is binding on them. Maybe that the government officials are not parties, but unofficial respondents are parties. And the matter went up to Supreme Court. And it was affirmed everywhere. Now they cannot come and say the government is not a party, therefore that order does not bind the government. It binds them.
The order dated 25th January 1980 binds you, not the question of not binding them.
When it is binding,
order of cancellation of your assigned land binds you.
My submission to your lordship says, it was already adjudicated.
So what right do you have to continue in possession of a land in respect of which you are not entitled? How can you continue?
My submission to your lordship says the civil court has already decided that the cancellation is not valid. Once the civil court decides, that order is binding on the revenue courts.
1 minute, you told us that this thing, 25th January 1980 is not has been set aside by any court.
The executing court held that there is no cancellation.
How can executing court go behind the decree and hold, Mr. Your decree is for declaration and possession? No, the executing court holds, they adjudicates the right. And they travel beyond the decree and adjudicate that there was no cancellation. You tell us, Mr. Please tell us from judgment and decree dated 24/7/19. See, judgment and decree dated 22/4/1978 could not have examined the validity of the order. It was passed subsequently. Executing court cannot travel beyond the decree and hold that this order, if it is such an order, we cannot take cognizance. That order dated 20, you are not saying. Please understand, 25/1/1980 binds you, Mr.
It's a case where, in the execution of
we have understood.
In the execution of a decree, they made a claim saying that it is patta is given to them and my patta is cancelled. That's an assertion which they made.
No, Mr. You are admitting that 25th January 1980 order has not been set aside by any court.
That has not been communicated. We do not know whether it actually is there or not. In the counter for the first time, they say they did not even produce any document before the lordships. Nothing to indicate that it is.
January 80 order not produced, madam.
No, not produced during the course of proceedings. It was not produced.
Where is it? Is it in existence?
Yes.
It's there, Mr. You produce the original record, we will see if the order is there. So shall we record your submission that it is non-existent?
Well, yes, minutes. It is never served to us. It is never served to us.
Even if
It is never served to us.
at the time of filing arguing writ appeal, it's very easy to say.
Well, it's even in the writ petition, but that's
No.
the assertion.
This all, I mean, this all. We don't think these issues relating to disposition, etc., are in the realm of Article 226. We don't
We
think.
have in fact stated in the counter affidavit in the writ petition itself, my lord, paragraph.
Only a private dispute between nothing, no element. What do you think? Very clearly. No, this order has not been set aside. So fact remains that this order dated 25/1/90 is not set aside, right?
Well, the civil court, my submission to lordship says civil court decide the issue, that there was no cancellation.
All right. That we will record.
But the executing court decided it, upheld in the, by the district court, by this honorable court.
This all without jurisdiction. This is we will hold, if you relying on that, we will hold that such a finding is without jurisdiction. Executing court cannot travel beyond the decree and not declare an order which was not even subject matter of suit to be void.
Well, that is fine.
It has not done so. All right.
Whatever the pleadings are, well, pleadings have to be proved, they did not prove it. Well,
Yes.
that has already attained finality.
Anything else? That's all.
That's
All. This this intra-court appeal has been filed against an order.
So infectious matter.
Yes.
Affected builder. Not the present writ petition is filed. The present writ petition is filed seeking to consider my application filed for regulation of government land. Regulation of my position over the government land. Made application pursuant to GO issued by the government.
GO does not subsist as on today, Milord. The GO does not subsist as on today, Milord.
But subsequently, I filed one more writ petition by availing subsequent GO, Milord, which is also pending.
So this is infructuous, right? Subsequent. Learned counsel for the petitioner submits this is nothing survives. You can prosecute your subsequent writ petition, right?
Obliged.
Not the next item, that is item 25.
Yes.
But as it is, it has become infectious, Milord, on the ground that the writ.
You could have put learned counsel for the appellant.
But some few facts, Milord, needed for the disposal, Milord. Some few facts. Your Lordship may bear with a minute, Milord.
Your statement is not sufficient.
No, Milord. Actually, what has happened, a writ petition was filed, Milord, challenging the granting of building permission in favor of the second respondent based on an unregistered sale deed, Milord. But the writ petition was dismissed, Milord, holding that the appellant has to file a civil suit. But questioning that, the present writ appeal has been filed. And Milord, this also, Milord, granted interim orders to the effect that constructions are subject to the result of the case. Now the building permission, Milord, which was granted on 11/4/2007, lapses, Milord, in 2010 itself, Milord. So therefore, Milord, the cause in the writ appeal as well as the writ petition does not survive. Milord, my humble request before your Lordship says both writ appeal as well as writ petition has to be dismissed as infructuous, Milord.
So that's what we are. Your statement is sufficient, we said.
Yes, sir. Yes, sir.
You are for appellant, no?
I'm for appellant, Milord.
Then it's enough. Learned 25 learned counsel for the appellant submits that on account of efflux of time, the issue involved in this appeal, which essentially pertains to validity of building permission, does not survive for consideration. In view of aforesaid submission, the writ appeal is dismissed as infructuous.
Writ petition also has to be dismissed as infructuous, Milord, instead of writ petition also has to be dismissed as infructuous.
The writ doctrine of merger applies, no? What?
Yes, sir. Yes, Milord. Much obliged.
What? Yes.
Covered.
Yes, Mr.
Copy of the order is submitted, Lordship, covered by a last order, Lordship.
Mr. Yes, covered. Which page?
I submitted a order. TS, Lordship.
All right, disposed of. Yes.
The M.
Page number 15, my lord. Order.
What are you saying?
Is Lordship. By
PG.
is MDS, Lordship.
All right, MDS.
MDS, Lordship, Master of
Oh. Yes.
CC today, Lordship.
Today.
But I am for the respondent. Let's have prepared a brief note, minutes in this matter. The dates of events and the pleadings of the respective parties. As the dispute in the writ petition is, an appellate authority's order was challenged by the writ petitioners. That's under Inam's abolition act. As land single judge examining the matter on merits as well as declined to exercise the jurisdiction under discretionary jurisdiction was not a.
Also, nobody is appearing.
Yes, that's correct.
'27. Let's see why today again you will find restoration. We will decide it on merits only. Let's see what not too complicated.
As the first page is concerned, a list of dates and events. Then, I have also extracted the pleadings of the respective parties. As the petitioners have filed an application under 10 of the Inam Abolition Act for grant of
1 minute.
I'm sorry.
What is ORC?
Occupancy right certificate, occupancy right certificate.
What is this Neeru the service?
Neerudi Inam. That is a service Inam but the very register itself does not, the Inam register of the consent tahsil, this land is not included, and right from 1951 it is recorded as a government land. The primary authority has not verified with any record.
Presenting Mr. S.C.V. Srinivas. Mr. Srinivas, counsel for the petitioner. In fact, Mr. Srinivas is unwell.
No. This last year you were granted time 1 year, 6 months ago.
That I am not the counsel, but even otherwise.
No, don't be counsel. Let's see before you must see the order. 2010, 13 years, long enough time. Right. So either you argue or don't argue. We will pass an order.
Only submission, my lord. Assailing the entry order passed by interim, learned single judge, my lord. This writ petition has been preferred, my lord. In fact, my lord, the petitioners before your lordship, my lord, the plea that was taken by the petitioner, my lord, it so happened that, my lord, the petitioner was the occupancy right certificate was granted to the petitioner, my lord, by the third respondent. Challenging the said order, my lord, it so happened that, my lord, an appeal was preferred by the joint collector, and the joint collector has set aside the order, my lord, and being agreed by the same, this writ petition was preferred, my lord. My submission, my lord, as far as the petitioner is concerned, my lord, claim for the title, my lord, is, my lord, the land pertains to acre 5.20 guntas, acre 5 acres 20 guntas, my lord, and the version of the petitioner is, my lord, they have done certain service to the crown, my lord, that is the then Nizam, my lord, which is called as Nirari service. So in fact, service, my lord, and for that service, my lord, they say that, my lord, an inam has been granted to an extent of 5 acres. Thereupon, what happened is, my lord, the government has preferred a case, my lord, on the provisions of land grabbing, my lord, stating that, my lord, since time immemorial, they were in possession of the land. It's not that, my lord, all of a sudden they have come into the possession. But unfortunately, my lord, the land grabbing tribunal, my lord, gave a finding stating that, my lord, the government is the owner of the land, my lord, and these people are the possessor. Therefore, my lord, they cannot be turned under the parameters of land grabbing. That was the opinion that was expressed, my lord, by the land grabbing tribunal. Subsequently, my lord, an application for occupancy rights certificate was applied, my lord, and same was granted, my lord, on the finding given by the land grabbing tribunal. And now, my lord, the point that was referred by the appellate tribunal by the joint collector is that, my lord, that nowhere, my lord, in the order that was passed by the land grabbing tribunal, my lord, it was declared that, my lord, the petitioner is the inamdar of the land. He is not the inamdar of the land, nor he happens to be the owner of the land. It has been all along stated that, my lord, the in the order passed by the land grabbing tribunal, that the petitioner is only an occupier and occupier with consent. My submission, my lord, the aspect that was raised in the writ petition is, my lord, when he is not the inamdar, the question of invoking Inam's Abolition Act is not arise. That is the point that was raised. He is not the inamdar. Even if the plea that was taken by the government is.
Why did you file an application if it was not you were not an inamdar? Why did you file an application?
The issue is, my lord, that since I am in occupation, I myself am saying, but the government deny that, my lord, that I am not an inamdar. Therefore, on this aspect, my lord, it was adjudicated, and by stating that, my lord, I am not entitled to, I am not the owner of the land. Therefore, the writ petition was filed, my lord. In fact, my lord, the order passed by lone single judge, my lord, goes in the very same line. In the very same lines as the appellate authority has passed. The very same aspect, my lord, that in the SGT tribunal, my lord, it was mentioned that nowhere it has been mentioned that he is the owner. My submission, my lord, it has been mentioned in the order, both in the appellate before the appellate authority as well as before the original authority, stating that, my lord, this petitioner, my lord, was in possession, my lord, as per even his parents were in possession of the property and his ancestors were also in possession of the property. This aspect was not disputed, my lord. Therefore, my lord, by virtue of a long possession, my lord, of more than 50 years, my lord, certain rights accrue to the petitioner, my lord, and therefore, my lord, the authority before whom they have applied for filing this for declaration, my lord, is not the competent authority to declare the title of the property. the authority, my lord, that is the appellate authority, my lord, is not the proper authority, my lord, to declare that the, my lord, to declare or ascertain a title of the law. That the plea that was taken by us is, my lord, that the plea of res judicata was taken, my lord, but unfortunately, my lord, the issue of title was not discussed with you. That's the only submission. Lordship may pass order somewhere. I'm sorry, my lord, I could not assist the case properly.
No,
I am not the advocate on record.
Thank you for the assistance, whatever you have rendered. Yes. This intra-court appeal. Huh?
My pleasure. That's,
He's
that's,
appealing.
my pleasure, Lordships.
Yes.
Apologize when I'm purchasing,
One
I'm appearing virtually, my lords. That's, this matter also arises under the Andhra Pradesh Telangana area abolition of Inams Act 1955. My lord, the appellants are the original Inamdars, my lords. And the ORC, that is the occupancy rights certificate, is granted in favor of the original, in favor of the unofficial respondents on 9/5/95 at page number 19, my lords. Brief history of the act is like this, my lords. The act was all the inams were abolished in 1955, and four categories of persons were granted occupancy rights certificate. Whoever among those four categories are in possession as on 1/11/73, they were found to be entitled into to occupancy rights certificate. They are Inamdar, Abize Kadim, protected tenant, non-protected tenant, and occupants, my lords. The respondents do not fall under any of that category, my lords. The respondent claims that they have purchased the land in the year 1966 from the Inamdar. Your lordship may kindly come to page 32. That is the order of the appellate tribunal, my lords. Page 32. Relevant portion is page 34.
No, Mr. Come to page 9.
My lord, it's
Page 9 of the other past by learned single judge last page.
Yes, my lords.
Ah.
Learned single judge
Claim.
observed.
Ah.
My lord, that
Last 3 lines,
confusion
please
that. Yes, my lord.
read last 3 lines.
My lord, the petitioners claim as successors of Kammari Razayya, but
Ah.
there is no such proof placed before the court.
Ah.
My lord, this is factually incorrect. That is why I am trying to invite your lordship's attention.
So what is the proof? What is the proof you have placed?
My lord, page 34, they themselves concede that the unofficial respondents concede that they have purchased the property from my grandfather. Page 34. After about 5 lines.
Huh?
Page 34, my lords. After the original Inamdar and occupant, Kammari Radhaya. My lord, I am the grandson of Kammari Radhaya.
No, where are you reading, Mr. Page 34.
Page 34 of the material papers, my lords.
Material paper.
Yes, my lords. It is order of the appellate authority which starts at page 32.
Joint collector. Ah.
Yes, my lords.
Joint collector. No, order of the joint collector. 11:3.
Yes, my lords.
No, but you,
Yes,
where are you reading? That's a long, this thing, 1 page.
My lord, first, second, and third page of the order, which is numbered as page 34, my lords.
Ah, 34, where are you reading? Where, what? 34.
Six lines from the top, my lords. The original Inamdar. Your lordship got it, my lords?
Ah.
My lord, the original Inamdar and occupant, Kammari Radhaya, sold the land to the grandfather of this respondent in the year 1966. So they are admitting that my grandfather was the Inamdar and he purchased from my grandfather in 1966. But the short point involved is in this, my lords. Assuming concurrent findings are staring at.
No, Mr. Brief facts. Brief facts alleged respondent number 2 are.
Yes, sir. That in the memorandum of appeal, that the appellant received information about the impugned order in OS number 7, sir, is absolutely false and vague. No date of alleged knowledge is mentioned. No plea, much less proof that they had no notice of the impugned proceedings or record of rights and mutation made consequent thereto. The Inams Tribunal RDO clearly show that before granting the ORC, the Revenue Division has called for report from the Mandal Revenue Officer.
Counsel. Your only the submissions. The question posed is, see, the question posed by this court at page 9, if you see, is there any proof
of title or any assignment or any certificate. You said it is there and you started reading the submissions. Do you have any document?
I apologize, my lord. Their submission itself is that they have purchased the property from the Inamdar, who is my grandfather. That is their admission at page 34, my lords.
So ask him what.
I'm relying on,
We don't.
I'm relying only on the admission made in their pleadings, in their arguments, my lords.
Is there, therefore I need not. So you are saying that since admission has been made, therefore I need not produce any proof. Is that the submission?
That is the number one, my lords. That is one submission. I will leave it at that. I will leave it at that, my lords. I am switching to next submission, my lords. First submission is your lordships have your lordships have pointed out that I have not filed any document.
We have not pointed out single. We have not pointed out single judge held so, Mister. Against that order, you have filed an appeal.
Exactly, my lord. Exactly.
So then, so what is the proof, Mister, that you are the successor of Amri Radhaya?
My lord, except the admission shown at page 34, I have not filed anything, my lords.
Admission, what
That
is?
is number one, my lord.
Amri, occupant to grandfather. No, that is grandfather, it has been sold. Grandfather of respondent. This respondent is, you are respondent number 2. What is your name? There's nothing.
He is the appellant. He is the appellant there.
Appellant there?
I'm sorry, my lords. My lords, I have no case, my lord. I'll fairly consider.
No case.
But your lordship may not. Your lordship may not regard it, your lordships are right, my lords.
We will
Your
not.
lordships are right, my lord.
No, we will.
Your lordships are right, my lords. Pardon, my lords?
No, we will not record that you have conceded. We understand the difficulty. Yes.
I leave it to your lordship. I will mobilize, my lords.
All right, mark the Yes. Madam, we asked you yesterday how many writ appeals are pending. Have you found out? When? Today. How can he say maybe? It's 50. It's 50. There is a direction between. Yours filed a petition. Petitioner. Appeal. He said dismissive title. Dismiss. Review level disorganized by franchise of the work. On 11/8/2010, none had appeared on behalf of the appellant. Today also, when the matter is called
Your Lordships, I am representing the respondent counsel, Your Lordships, Mr. K. Ravindra Kumar, Your Lordships. In fact, this matter pertains to Kakinada Port, Your Lordships, and this matter has to go before the Honorable High Court of Andhra Pradesh, Your Lordships.
Why? What is the dispute?
By mistake, the district has been mentioned as Hyderabad, Your Lordships. That is the reason it has been left out in Hyderabad, but the district is East Godavari district in Andhra Pradesh, Your Lordships.
The office is directed to transmit the records of the
Take over there.
What is it?
Synopsis.
No, that's correct. What is the
The further transfer the joint collector, levying the division file with respondent 4 to 9 minutes. It was challenged before the line single judge dismissed the petition.
See, you have written here in this synopsis, third respondent, that is Tehsildar, right? Dismiss the petition filed by respondents 4 to 9.
Yes.
Then you say that thereafter that 4 to 9 file an appeal before joint collector. Then you say after 1 year filed revision.
So typical mistake, so they file appeal before the RTO. It's a joint collector, it should be the RTO.
Ah.
The appeal was,
Then what happened? They filed an appeal, then again filed a revision.
they file an appeal, they withdrew the appeal, then they file revision before the joint collector.
So appeal filed before RDO.
Yes,
It was withdrawn
withdrawn
and then filed a revision.
before the joint collector.
Ah.
But the joint collector allowed.
As allowed.
Allowed the revision.
Why?
On two grounds. One, that no notice was given to the respondent 4 to 9 before effecting the notation in favor of the appellant, and then such a file is not available in that respondent.
That is one ground itself is sufficient.
Kindly page 29, the order passed by the joint collector.
Before mutation of name of the applicants.
But that was mutation in favor of the appellants was effected in 1983.
Without giving notice to applicants, respondents 4 to 9.
I may permit to say a few facts, but originally not the P. Gobaya is the original Pattaya next under 8 acre 13 guttas. In survey number 7 of
That we have read it, right? Whole thing. We have read it what you have given no for
Yes.
that very purpose.
But irregularities of the not the P. Gobaya. So
No, Mr. Whether your name could have been mutated without hearing 4 to 9.
but it was not kind what happened in this case? When no, in fact, no, but my
Asking.
What are the findings of the learned judge?
the other thing also gave a finding saying that no notice was issued to the not the
No. Final in the order. What were the findings? Please go to page 19 and 20. It is a fit case to be resolved in the civil court.
Yes.
Now your appeal, you have to argue how civil court is not having the jurisdiction. Please make your submissions on that grounds.
But my submission is no notice is required because the learner single was held that not the chinnam nor laid out with the chinnam contract was not followed, wherein notice has to issue to another parties. So the chinnam contract of case arise under section 5(3) of Act, whereas the present case may arise under section 3 of RO Act, Amendment Act. Therefore, no notice is required to be issued to the no notice is required to the persons. You not kindly see not. In fact, not lost my page. Page 200 and 198, 198, 199. Initially, mutation was done in favor of the first appellant and his mother. Page 199. And the respondents also filed a suit for cancellation of sale deed.
No answer. That's why he is arguing.
Just go ahead.
Page 199. The petitioner purchased the property from Srimati Sheila in Notia, who purchased the property from the original legalizer of the original Pattaya. But notice was given to column number 6. You not kindly see. Notice issued to, and there was no objection from any corner well within the time given by 15 days. Hence, implemented in the material register. They verified with the contents of the patwa and found correct. Hence, the proposed mutation proposed in favor of the person whose name entered in column number 5 may be sanctioned. Following find what the petitioner's not the appellant's mother, Sandha bin Patel, who purchased property from not the Sheila in Lothian. And moreover, this mutation was effected 1983, but after lapse of the 30 years, they filed an application of revision before the joint collector. There is no explanation for the delay. And they also filed a civil suit not for cancellation of sale deeds. The civil suit appears to be pending. But page 15 it also tells ordered passed by the land assembly.
You were respondents in the writ petition, right?
I am the writ petitioner.
But you have stated that your clients are taking steps to get the sale deeds
No, that is the
cancelled in the civil.
that is the file by the respondents. I am the writ petitioner.
So what is like a entry in the revenue record does not confer any right. It is subject to decision of the civil suit. If the civil suit is pending, it is dismissed, you get the entry made again.
But after 30
And
years
nothing.
of patient proceeding, there is challenge in stage. In the stage arising but in the context of section 5(3) of ROR Act. But whereas not issue in relation to section 3 of ROR Act and then
Okay, what Mr. in your favor will not be this thing. You will not become a owner of the property, correct? True, no or not? What is the legal position?
Revenue entries does not confer any title.
Then
Yes.
that's what we are saying, that this all will be subject to decision. They have filed a suit seeking cancellation of the title deed executed in your favor. Supposing if that suit is allowed, what happens? Your name will be recorded, you will sell the property, run away.
I did not file the suit. They filed the suit for cancellation.
So what happens if the sale deed is cancelled? What happens? Nothing.
Once the sale is cancelled, everything is good.
Then that's what anything will be subject to result of the civil suit, right?
I am not aware.
Nothing to interfere.
I am not aware whether the suit is pending or not.
Good. You shouldn't be aware after 13 years. What is there to be aware?
They filed the suit. But my only submission is not.
The record is non-existent, Mr. That is.
But they question the proceedings after 30 years, but they reside in the
Nothing.
same village. So there is no.
Same village. You reside. Nothing, Mr. You understand the position. It is all, it's subject to result of a civil suit. Yes.
But
Hmm.
this
This.
may not be.
Huh?
The observation dismissing in the writ appeal are questions. Not any bearing on not suit.
No bearing. What? This is validity of an order passed by the joint collector. How it will have a bearing on question of title? Anything like. He says nothing. He understands. Nothing. Yes. In this intra-court appeal, Amadi
But the APO for the petitioners, one is representing KV Balapas. Right, the cause in the writ table doesn't survive.
Does not survive.
Yes, ma'am.
But you should say so, right? In the beginning, you could have said voting right. Supposing it would not have been called, you would have never said. Why? We are struggling to decide each and every case, right? So you should cooperate at least when the matter is like 1031 council said at item 78. You could have also said.
My apologies. Last again, I have sought time for taking instructions from the client.
A learned counsel for the appellant submits that on account of influx of time.
I beg to represent on behalf of Mr. Raghunath. The present inter-court appeal filed lordship to suspend the writ petition, lordship.
To suspend.
Writ petition number 12969 of 2010 year lordship. In that lordship we have challenged the action dated public notice, public action dated 29/5/2010 year lordship. As I have gone through the counter of the first respondent, your lordship. In that lordship may kindly see page number 24, your lordship. For a moment, your lordship. The present first petitioner filed the writ petition.
What is the order which is under challenge, madam?
Lordship. The
Auction has been held on 29/5.
One submission, your lordship. Lordship may see the counter of the first respondent, your lordship. In that he has filed the writ petition, lordship, to challenge the present year public action, lordship.
Who has filed?
First respondent, first petitioner, your lordship. First petitioner alone, he has challenged the action pertains to the this year lordship. The difficulty is that lordship, I have not in contact with the petitioner.
You will not be in contact after 13 years.
Whether the cause survives or not, that is the
Then nothing it survives. You argue.
This year
Yes.
But in fact,
she doesn't know anything, right? Not in contact. So we will dismiss it, madam.
lordship may give 1 week time, lordship, whether
No, nothing week's time. Nothing. Forget about it, madam. After 13 years, the client is not in touch. What do you think? After 13 years and 1 week, he will get into touch. Nothing.
whether the cause survives or not.
Nothing survives. It survives. You don't know what. You have not even read the impugned order, just seeking adjournment like this.
No, lordship.
Auction has already been held, madam. There is no irregularity in holding the auction. Please point out why it should be set aside after 13 years.
But I'll argue on merits, your lordship.
No, nothing. There is no question of arguing. It is being decided today itself. When will you argue? Nothing.
Lordship may.
No. Forget about it, madam.
Lordship, I'll argue on merits.
Also argue, right? This is listed for argument on merits.
Lordship. As per the notice on 9/7/2008, your lordship. Lordship, may kindly see 27 of my writ appeal, your lordship. As per this notice, lordship, I paid the rent, your lordship. That is in page number 32. That was refused, lordship.
You are madam, simple facts are which you are not telling that you are a landless person. No, you are a.
Your lordship, then
You are a landless person. You are allotted lease, land on lease by the temple. You did not pay arrears of rent. Thereupon, those rights were put to public auction, and you challenge that.
See, lordship, I paid the rent, lordship, but they refused on that on 12/5/2008, Your Lordship.
This is
Stating
all
that
not
your-
recorded in the order, madam. The findings are you were not paying rent. Subsequently, public auction was conducted.
Petitioner alleging defaulting payment of rents, Your Lordship.
That's it.
By stating that only they are dismissed, Your Lordship, but they are refused the ground that Lordship.
That's the booking position.
Lordship may kindly see page number 28 for a moment, Your Lordship.
Yes.
For a moment, Lordship. In second para, Lordship, the lease for the year 2001 to 2 are paid, but you have to pay lease for 2002 to 2003 and 2007 to 2008. I for 6 years within 1 week from the date of this notice. Otherwise, the permanent lease right will be forfeited. He, as per this Lordship, he paid the lease, Lordship, but they paid the lease on dated Lordship in month of second Lordship, second and third Lordship, but they refused on 12/5, Your Lordship, for a moment on page number 26, Your Lordship.
This 2 year has expired, madam. Nothing survives for adjudication. 2010-11 land for they were auctioned for a period of 1 year that has expired. This intra-court appeal, yes.
Lordship may say this.
This intra-court appeal,
And
we are saying this.
Otherwise, Lordship may say this Lordship he has filed.
It has become infructuous. We are saying so. You should say so that it has become infructuous instead of seeking adjournment.
Not,
No, madam, the client won't tell you. You have to find out. We found out from this your petition that the auction were held for 2010-11. Yes, in this writ petition, in this intra-court appeal. It has not become infructuous, right? That's what you want to argue.
They have been filing several, have been filing several writ petitions. I was on record for the manager of the temple, and I took permission when
No, we don't need your assistance, mister. We are recording a finding. If you are aggrieved, go to Supreme Court. We are holding that writ petition has become infructuous. If your manager is aggrieved by this order, you should go to Supreme Court.
recently also they filed, they are troubling the even at their temple. They recently also they.
So in this appeal, we should say that they should not trouble the temple.
Nothing remains.
Mr. Praveen Kumar, see what this intra-court appeal is filed against an order date.
May I please, I am for the respondent. I am for the respondent, my lord. It has been brought to the notice.
May I please, Rose?
Petitioner has expired.
Miller.
The appellant is no more.
We filed application for bringing LRs on record, my lord. The applications are not listed, my lord. IA number 1, 2, and 3 of 2020.
What happened this petition? What happened? There was a stay.
No stay, my lord.
Then see the order operative portion. Whether it survives, Mr. That's what.
It survives, my lord.
How? Disposed of, it shall be open to the petitioner to file application. You read it, Mr. It's not our case.
Yes, my lord, I read it.
Then
Only thing is, while
4 weeks considered on their own merits, nothing.
the petitioner have no particular passbooks,
Tell him.
the learned single get directed the authorities not to.
No, no, if it has been decided, then it gives you a fresh cause of action. Nothing survives. Nothing survives in the petition. Appeal, Mr. You understand, please.
The document is still in the market.
71 Act is repealed, not now 2020 Act. You have to make an application online.
Online, whatever, I mean, whatever was done, there was a direction, there's nothing survives in this appeal. And the writ petition preferred, mark the presence writ petition preferred by the
Third party criminals have filed the writ petition not to take action against them. And the learned single J gave right to protection to them. Question that because they created fake documents in
Protection?
the appellant's land.
No, no, which case, this is item number, Mr. 34.
34.
34. What is the order, operative portion of the order? 1 minute, operative portion. First of all, don't show like this. If we talk to you like this, will you like it? No. Please keep your hand down. Hand down. Hand down.
Counsel for the appellant, Millard, I may be permitted to make some submission.
Yes. So we are asking you to read operative portion. Operative portion.
The appeal is directed against the order of learned single J's to give protection to the criminals who filed writ petition.
Third party.
The petitioners, Millard,
Appeal with leave petition. Third party appeal.
land of the appellant
Third party.
and went to bank.
With leave application, not
What criminal? What criminal? Who is criminal?
writ petition is.
Writ petitions.
Writ petitions are the appellant respondents herein. The appeal is by the third party.
Third party.
Yes.
So what is it?
The leave granted to the petitioners in the writ petition, my lord, is being questioned by the third party that he got some interest.
Millard,
There is nothing, Mr.
I'm sorry, Millard. The
There is no
petition
this
is not to be sold by the writ petitioners.
But keep your hand down, Mister. Don't show. It's not a good manners to point fingers at somebody. Don't keep your hand down. Speak.
Millard,
You have to speak from the mouth. Don't show your hand. Yes.
I'm sorry.
Please go ahead. Please go ahead. We are ready to hear.
The writ petitioners, Millard, filed the writ petition against the authorities who sought to take action against them for creating a fake documents in respect of land of the appellant. They made an attempt to.
What is the direction issued by learned single judge? We are asking you again to read. What is the direction?
Right, sir, there is not to take any action against the petitioner.
Nothing.
Yes, my lord.
What was-
The
All
letter is
right.
not to take any action against the.
Not to take action against petitioner. Fine. Yes.
Not to take any action to the writ petitioner on the basis of the existing documents. They are fake documents. Alleged to, not alleged, found to be fake documents. In one such document is created.
And there is no stay in this writ appeal pending for 13 years. Do you know that the petitioners have not filed any application and no orders have been passed?
My lord, writ petitioners approach the bank for loan by producing the fake documents in respect to the land of the appellant. So, my lord, the learned single judge directed the respondent authorities not to take any action against the writ petitioner.
No. So how are you concerned with the land? You proceed against the under Securitization Act. If you are a bank, proceed under Securitization Act, recover the money. If you are not concerned with the land.
So they have created fake documents.
No. This is you are not bank.
But he can maintain
He
an
is
application.
now.
He can maintain an application as the right of action before the authority.
Mr. What? This is the difficulty is that he is not prepared to understand that there is no interim order in this case. 13 years ago, the direction was issued. 13 years ago, direction was issued. By now, the application may have been filed, may have been decided. He doesn't realize what can be done. Argue, Mr.
Apart from that, appellant is no more, my lord. They are not filed any LR petition.
Appellant is no more. No, but there is nothing, right? See, Mr. We don't want, we are allowing the application. You are filing the application.
LR petitions IA 1, 2 and 3.
When have you filed?
Then I filed about last month, my lord. They are numbered, my lord. IA 1.
When have you filed? Date.
Second.
Third
of this month, my lord. Third of this month. They
Third
are
of
numbered.
October. We will allow the application, don't worry.
They are numbered, my lord. They are not.
Fine, we will get it, don't worry.
In fact,
You argue on merits, IA 1, 2 and 3.
in fact, they are not, sir.
No, it has, the registry tells us that you have not filed. What is the number?
I have numbers. Number 1, 2 and 3.
No, Mr. What is, there is some filing number, right?
Yes, IA numbers I am giving.
Filing number, no, the IA number, USR number. What is
They are
USR?
numbered. So no USR numbers are required. Yes, are already numbered. Yes, are numbered.
Don't tablet. So go ahead, Mr. Argue whatever you want.
No, your argument direct registered to list to IA 1, 2, 3 along with this appeal.
No, those applications are allowed. If you have filed it, they are allowed. You argue on merits. There is nothing.
Yes, your argument. Take it up someday, not today.
No. Today is the right date. 13 years.
Yes,
He has died also. You don't want to. It will be a tribute to deceased petitioner to argue the appeal itself today.
I will argue now on merits, my lord.
Yes. Please argue.
We take up the impugned order.
I'm sorry for interruption. In fact, they are not filed any IA number 1, 2, 3 this year. They are filed at the year, in the year 2010 of condemnation delay dispense with petition. Those are filed in the year 2010, not now, my lord.
He is saying 3rd October and his statement is found to be incorrect. We will take action against him. He has said IA 3rd of October 23 is filed. If the IAs are not filed, we will take action against you for misleading the court. Yes. Yes. Please argue on merits. We are believing that you have filed an application.
Yes,
See, Mr. There is a factual dispute even on this, that whether or not you have filed the application. What is?
We take up the impugned order, my lord. Impugned order is yet A7.
Yes, go ahead, Mr. It's not.
This is, my lord.
The petitioners approached the manager of Jillela branch, State Bank of Hyderabad, both responding here with a request to advance loans since they are agriculturists.
Ask madam.
Certain lands, landed property.
IA 1, 2 and 3, whether filed on 3rd of October 23. Find out. And take a statement from them if it is not filed. Yes. Yes, go ahead. Please go ahead. Yes.
Petitioners approached the manager of Jillela branch, State Bank of Hyderabad, both responded here with a request to advance loans since their agriculturists owning certain landed property. Their particular passbook is before the fourth respondent. He addressed a letter dated 12/9/2008 to the Revenue Divisional Officer, Sicila, the second responding hearing, to verify the genuineness. The respondent informed the fourth respondent through the letter number 2008 stating that out of the 6 particular passbooks sent, 2 are found genuine and others are no entries are found in the records are maintained by the Tihsildar office in relation to the books said to have been issued in the names of the petitioners. It was pointed out that they are not genuine and a copy of the letter was forwarded to the station house office of Sicila for investigation. The petitioners feel
What is this an argument, Mr. or what? You are reading something. We have asked you to.
I'm reading the impugned order, my lord.
We have read it, Mr. That we have done. You go ahead. What is your submission? Why the order should be set aside? You please tell us.
No, your lordship, kindly go to. Your lordship, kindly go to the counter filed by the RDO, where it shows the one survey number belongs to appellant. For that, a fake document is created by the petitioner, writ petitioners, and approach the bank for loan. So that's the grievance.
Yes.
That's all, my lord. Your lordship, pass on.
All right. Thank you. Yes, Mr. Yes, Mr. If you want to say anything, say.
In fact, the honorable court had directed.
So, did you file an application? What has happened? Nothing. Don't know. Very good. Yes. Yes, madam. Mark the presence. Heard this intra-court appeal. Delete. This intra-court appeal has been filed against an order dated. What date? Order dated 16th March 2009, passed by learned single judge, by which writ petition preferred by respondents 1 to 4. Respondents. Writ petition preferred by respondents number 1 to 4. 1 to 4 has been disposed of in the following terms. Quote this, therefore, right? Paragraph. Facts giving rise to filing of this writ petition briefly, this appeal briefly stated that respondents 1 to 4 approached the manager of State Bank of Hyderabad with requests to advance. The respondents 1 to 4 who are agriculturists advanced State Bank of Hyderabad with request to advance the loan. Full stop. The appellant, the respondents 1 to 4 produced the pattadar passbooks before the bank, who in turn addressed a communication dated 12/9/2008 to Revenue Divisional Officer to verify the genuinity of the passbook, pattadar passbooks. Full stop. Paragraph. The Tehsildar, no, whatever, the Revenue Divisional Officer by a communication dated 1/11/2008 informed the manager of the bank that out of 6 pattadar passbooks, 2 are found to be genuine and no entries are found uh, no entries are found in the records maintained by the Tehsildar office in respect of in the office of Tehsildar in respect of remaining pattadar passbooks. Full stop. The full stop. The a copy of the communication was forwarded to the station house officer for necessary investigation. Full stop. The petitioner challenged the validity of the communication dated 1/11/2008 in a writ petition. Full stop. The learned single judge disposed of the writ petition preferred by respondents 1 to 4 with the directions as aforesaid. Full stop. Being aggrieved, the appellant, who is not a party in the proceeding before the writ petition, before the learned single judge, has filed this appeal inter alia on the ground that he is owner of the land in respect of which land in question. Full stop. Land in question. Full stop. Paragraph. We have heard learned counsel for the parties at length. Full stop. From perusal of the order sheet of the proceeding, it is evident that this appeal is pending before this court since 2010, in which no interim order has been passed. Full stop. The respondents 1 to 4 may have filed the application for issuance of pattadar passbooks to third respondent. The fate of to the Tehsildar, the fate of the applications is not known. Fate of the applications filed, which may have been filed by respondents 1 to 4, is also not known. Full stop. Therefore, at this point of time, interim suspension. Correct. Huh? Who? This inter-court appeal is filed against an order dated
May I please? This matter, my lord, the matter is settled outside court. The matter is settled outside court. Today only I have filed a joint memo in the registry, my lord. The lordship may have this matter tomorrow.
Why tomorrow? Why tomorrow? Give it.
USR number is there.
This intra-court appeal has been filed against order dated 4th April 2007 passed by learned single judge by which writ petition preferred by the appellant
May I please, Your Honor. Your Honor, this writ appeal is filed, my lord.
Yeah, what is this 40 to 44 bunch? All right. 37. All right. Yes. Yes.
May I please, ma'am. Your Honor, this writ appeal is filed being agreed. Your Honor, assailing the order of the learned single judge. Your Honor. Order dated 27/4/2010 in writ petition 19319 of 2001. My lord. I have made a list of dates with the pagination. My lord. May I pass on the list of dates? Lord, we are agreed by the operative portion of the order, my lord. The issue is this, my lord. My lord, in 2001, my lord, there was in 2001, my lord, first on 27/12/2000, my lord, there was a tender floated, my lord, by the Food Corporation of India, who is the appellant here.
1 minute. Who are you in the? You are a petitioner.
I'm for the Food Corporation of India, my lord. We are the appellants, my lord, here.
No. In the writ petition, you are respondent, right?
We are the respondents.
What is the order?
My lord, the operative portion of the order said this, my lord. Before I come to the order, I'll have to briefly tell what the facts are, my lord. May I, or I'll take your lordship to the operative portion?
No. We are just trying to understand whether anything survives, right? Or is it against a finding?
Absolutely.
It's against a finding. Then what is the order against you?
Yes, my lord. The operative portion of the order, your lordship will find at page 12, my lord.
What is it? You tell us, Mr.
Yes.
You are here to assist 12, 14,
May I read
27, 35. That all we can see.
May I read out?
But you are here to assist.
Certainly.
No, do not read out. Rely on your memory. What does it say?
My lord, the learned single judge passed a declaratory relief, my lord. It declared that the petitioner therein, my lord, was eligible, my lord, to claim damages against the Food Corporation of India, my lord. My submission is, my lord, the learned single judge, my lord, had not taken into consideration several letters.
No. So whether suit has been filed?
No suit has been filed.
So then it has become time barred. Can't be filed.
I'll leave that to your lordship. That aspect I will leave out.
That's what we see. This not necessary to drag on every matter. You are here to assist. You should tell us.
Certainly.
That sir, this is the what has been done and no suit has been filed.
And
now it can't be filed.
Sir, I have taken instructions, no suit has been filed.
Be happy. Yes. This intra-court appeal has been filed. Yes, madam. This intra-court appeal has been filed against an order dated so and so.
Wait, please. Writ petitioner is the appellant here in your lordship. The question of law that arises by lordship's consideration is whether under section 61 of the Cooperative Societies Act, the relief of akin to specific relief could be agitated before the statutory or arbitrator, or whether the parties have to be relegated to the civil court. Lordship, under the Cooperative Societies Act, wherein your lordship the respondent 2 and 3 are a society under the Cooperative Societies Act, the member, your lordship, respond number 1, sought to alienate a plat in favor of the appellant herein. Part consideration was paid in respect of the balance transaction, lordship, as there was some delay on their part. The appellant approached the arbitrator under section 61 of the Act. The arbitrator allowed the lordship, which was challenged before the tribunal, but the learned single judge and the tribunal took the view, lordship, that it would not come within the jurisdiction of the arbitrator under section 61, and the relief has to be agitated under the civil court, lordship, under specific relief act. That's the only question, lordship, interpretation of section 61 of the Act, lordship. The findings of the learned single judge from page 11 onwards, the lordship would take.
Correct. Yes.
Your Lordship, pages 11, 12 of the learned single judge, court single judge took a view, Your Lordship, that it would not come within the purview of section 61 of the Act. My humble submission, Lordship.
And he has relied on a division bench this
Yes, Your
year.
Lordship. That judgment, Your Lordship, may be permitted to pass on, where the court in that case, Your Lordship, took a view that when certain sale lease cancellation was sought, court took a view, Your Lordship, that would not come within the affairs of the society or the business of the society.
It's a dispute in relation to specific performance of
Yes.
contract. So that would not be covered under section
61,
like
Your Lordship.
prima facie. It appears to us to be correct.
Your Lordship,
Subject to what you have to say. Learned single judge relied on a division bench
Yes,
decision.
while I bowed down, Your Lordship, the division bench, Your Lordship, took a view that these transactions, in that case, Lordship, where a sale deed was sought to be challenged, court took the view, Lordship, that would not be the business of the society. But that judgment also, Your Lordship, ended up in the Supreme Court.
See, the ratio is that the arbitrator will have no jurisdiction to entertain a dispute relating to specific performance of the contract. Correct?
Your Lordship, I bow down to that extent, Your Lordship, but may only make one humble submission, Lordship. In normal case, Lordship, Your Lordship, arbitrator might not have jurisdiction, but in cases like these where respondents 3 and 4 are societies registered at the Cooperative Societies Act and they control the sale transaction. Even if a person has to purchase, admissions has to be granted.
Any authority in support of this submission that case of cooperative society? Any authority?
Lordship, I bow down, Your Lordship. I have not been able to get any direct case law on that.
If the legal position is against you, there can't be. You should be Mr. fair enough to tell the court that the legal position is against me. Say so, and you can make that. Please do not record my concession to that stand. Is there is no point in arguing contrary to settled position.
I will make one humble request on to protect the appellant's interest. Under section 14 of the limitation act, he's been pursuing this remedy all this while. His agreement, Your Lordship, he still has a right to enforce it. So some liberty may be granted, Your Lordship, because he was bona fide pursuing this remedy under the act. So under section 61, because the arbitrator also did not say he did not have jurisdiction. Arbitrator
Instead of, having filed this appeal and waiting for 13 years, by now probably his civil suit would have been in final stages. The arguments he would have concluded.
Your Lordship, I bow down, Your Lordship, because it's
if you have anything to argue, we are willing to hear. What this thing? Otherwise, what we are only saying, don't argue contrary to settled position. If you have anything, you can demonstrate that this is distinguishable, does not apply. We are willing to hear, but don't.
Your Lordship, I bow down. As far as the legal position is concerned, the judgments are against me, Your Lordship. But since I may only make one humble request to protect the appellant's interest, Your Lordship may at least grant some liberty wherein, without reference to the limitation and under section.
Without reference, we will say it will be open for you to take recourse to such remedy.
Obliged.
This petition. This intra-court appeal emanates from an order dated list tomorrow. Don't say anything. It will continue tomorrow.